Hello? Oh.
Okay, good morning, everyone. I'm the staff attorney for Judge Rachel Krause. We are being live streamed on YouTube now. If anyone is requesting takedown, please let the judge know that when you make the announcement of your case. We don't believe anyone. Oh, sorry. We have a little live streamed on. If anyone is requesting takedown, please let the judge know that one. Sorry. Okay, that was the YouTube feedback. Okay, now that that's over with, judge is here. So I would just ask that you keep your screen muted until the judge calls to talk on you. And then, of course, don't forget to unmute when speaking to her. Again, please mention takedown when she calls the announcement if you want it.
Okay, thank you. Good morning, everybody. Most of the matters on this calendar this morning are pretty straightforward, very quick matters. So I'm going to take them up first. There is a reason that the Crayla Bryce matter is at the end of the calendar, and it's because it's likely to take the most time. It is set down for a pre-trial conference, so I'm just letting you know in advance. It's probably going to be 20 plus minutes before we get to that one, just to let you know. So let's go ahead and get started. Position number 1, Giovanna Moss versus Edge Auto Sales.
Yeah, I'm Michael Flynn. I'm here for the plaintiff.
Hi, Mr. Flynn. Have you had any contact with Ms. Moss or any reason to expect that she would be attending today?
Yes, Your Honor, I spoke to her 2 days ago, and we plan for her to be present for this hearing to offer testimony about the damages.
Okay.
I've texted her this morning without a response. But,
okay.
I gave her the link, and I expect her to be here. If you'll give me a few minutes to check on that, I'd appreciate it.
Sure, happy to. Thank you. I'll circle back to you, Mr. Flynn. Okay.
Thank you, Your Honor.
Thank you. High Point Road Recreation versus Christine Shaheed.
Good morning, Judge Griffin Bell for the plaintiff.
Hi, Mr. Bell. Have you had any contact with Ms. Shaheed or had any reason to expect that she might attend today?
We have not.
Okay.
I think, and I believe we filed our motion for default recently.
You did?
But no, we've had no contact.
Okay. And so what? Couple 3 minutes for your presentation?
Judge.
Okay.
And Judge,
yes.
They're here if you need her. If not, I'm happy to just do attorney's fees. So whatever you want to do.
Okay. I mean, generally speaking, I did look at the file last night, and you have filed everything that you needed to file in terms of documenting the nature of the claim. And so typically the only thing I would require of you is the attorney's fees, but some attorneys like to have that record. So if you wish to do that, I certainly understand.
Thank you, Judge.
Okay. Excuse me. It's Rivermont Community Association versus Rashun Gaddy.
This one's also me, Judge.
Okay.
We're in the same.
Okay. Same announcement?
Yes, Judge. Don't expect him to show up. Haven't heard anything from him.
Okay. Thank you, Mr. Bell. D&M Associates LLC versus Liberty Assets. Is David Basil on the call? Okay. Fulton County Sheriff versus Dorothy Hughley, if I'm pronouncing that correctly, et al.
Good morning.
Yes.
Brandon Wagner for the petitioner.
Hi, Mr. Wagner. How are you?
I'm good, Your Honor. How are you?
I'm doing fine. And I hear someone, I think, who's on a cell phone. Is that Ms. Hughley?
Yes, ma'am. This is Mrs. Dorothy B. Hughley.
Okay, thank you, ma'am. I appreciate that. Mr. Wagner, I note when I looked at this matter before, everything seemed to be, all the boxes seem to be checked in terms of what needed to be accomplished, but oftentimes we'll get a consent order. I didn't see one. If you've sent one over and I just didn't see it, I apologize. But what is the status of it?
I didn't, Your Honor. We have a pending motion to deposit funds, but I guess in this hearing, we can just do the final order and incorporate the deposit funds.
Right. So just to be difficult, what I like to do, Mr. Wagner, is, and honestly, it's not just to be difficult. It's because what I have found is that if I let you guys pay the money in, then you guys go on about your business, and then the claimants are left to sort of figure things out, and they often don't know exactly how to do it. Whereas if I, instead of letting you pay the money in, do it all at one time, then it accomplishes two things. One, the claimants get their due if they're entitled to some, but also I get a better order that tells the entire reference of the case. So if we have to go back and look at it later because there's excess funds, we all know what happened in one place.
Sure.
So that's one of the reasons that we schedule it the way that we do. And so how long do you think it will take for you to sort of present just the background of the case for purposes of today?
5 minutes, Your Honor.
Okay. And I know that Ms. Hughley is here. Is there any dispute regarding the relative claims? I saw that the state of Georgia and FSB were both served. Obviously, Ms. Hughley is the primary claimant, but.
So the Department of Revenue did file a claim in the amount of $23,1757. There's not a lot of excess funds here. So once my fees are paid and the Department of Revenue's fees are paid, Ms. Hughley would be entitled to the remainder, which again isn't going to be that much, but it's hers.
Okay, I understand. Well, and sorry, Ms. Hughley, I'm going to hear from you, but right now I'm just sort of getting an outline of how long it's going to take so I can figure out what cases to take up first. And at the appropriate time, I will hear from you about your position on the case. Okay, ma'am?
Yes, Your Honor.
Thank you. Okay, and then last but not least, I have the Crayla Bryce matter, which is set down for a pretrial conference. I'll also note that there seemed to be a motion for summary judgment or partial summary judgment, as well as a motion to bifurcate or sever, and then some various and sundry, I think, motions in limine, et cetera.
Good morning, Your Honor. Yes.
How long do we think that will take, Mr. Obaseki?
Well, those motions were filed primarily from SSA any assets. Our motion for summary judgment, I imagine, will take more than about 45 minutes.
Okay.
I'm not sure about opposing counsel's motions.
Okay. Mr. Barton?
Good morning, Your Honor.
Good morning.
On behalf of SSA, I think altogether we could probably handle our portion in about 15 minutes.
Okay, excellent. Okay, so I mean, given that in addition to that, we also have, some pretrial conference matters to address. So as I said, I am going to expect to spend a good bit of time with you guys, and it'll probably be in about 20 minutes or so. Okay.
I'm sorry, Your Honor. We have filed an answer response to the plaintiff's motion for summary judgment, as well as a motion in limine as well.
Okay. Thank you, Ms. Thank you, Ms. Claire. And you represent, is it Ms. Hayes and GPTC?
I represent Georgia Property Tax Solutions, Allen Enterprise, and Ashley Hayes.
Okay, that's what I thought. I just wanted to make sure. Thank you, Ms. Claire. Okay. So let's go back to the beginning. Mr. Flynn, I think, is still trying to locate. Nope. Hi, Mr. Flynn. How are you, sir?
I'm good, Your Honor. I haven't been able to get her on the phone or have a response to my text message, but I would offer that this is a default, and if you look at the complaint, the amount is actually liquidated in the $4,000 she paid for the car. So I would ask the grant judgment for $4,000 and offer evidence as attorney's fees.
Right, and I'm glad you got there, Mr. Flynn, because I was going to ask you the same thing. Is that if the amount is liquidated in the complaint, then there'd be no reason necessarily for me to hear from Ms. Moss. I am aware of the motion for default judgment that you have filed, and I had noted that service had been filed effective December 20th, and more than 45 days have passed since January the 20th. And so it would appear that Edge Auto Sales is in default. And if the amount is liquidated, tell me the amount again, Mr. Flynn.
Yes, thank you, Your Honor. The amount is $4,000. That's what she paid for the vehicle that the title was never delivered on.
Okay. And then you were also seeking attorney's fees if you want to make that presentation, Mr. Flynn.
Yes, Your Honor. I submitted an affidavit, but I would like to state in my place as an attorney licensed to practice law in the state of Georgia for more than 37 years. A reasonable hourly rate would be $350 per hour with an attorney with my experience in consumer law. I've stated the reasons for that in the affidavit more specifically, but in the interest of brevity, I'll just keep it at that. 10 hours is a reasonable period of time for spending on this case, including meeting with my client, drafting pleadings, motions, preparing for this hearing. And I have $370.60 in costs. So I'm asking for an award of $3,500 attorney's fees and $370.60 in cost, Your Honor.
Okay, and I do have the additional supporting matters that I think that you submitted. Did you submit, and forgive me if I overlooked it, but did you submit a proposed order?
Your Honor, I have not submitted a proposed order.
Okay, well, it would be very helpful to me, Mr. Flynn, if you could submit in Word format a proposed order to Mr. Freehoff at his email address.
I'll certainly do that
Yep.
before the end of the day, Your Honor.
Thank you so much, Mr. Flynn, and we will go ahead
Thank you,
and
Your Honor,
get that
for
file for
your
you. Have a good day.
indulgence.
Thank you. And Mr. Bell, High Point Road Recreation Association versus Christine Shahid.
Yeah, thank you, Judge. I believe the only changes since we filed our motion for default are going to be attorney's fees, but there also was a February 2023 assessment in the amount of $200. So if I can just get, actually, I think I did submit a proposed order, so you have all the numbers there in front of you. So I would just state in my place that I have been an attorney practicing this type of law for just over a year, but generally for 3 years. This is the standard amount of work. We did 10 hours on this one. We charge hourly rates from $195 to usually $350, but I did all the legal work on this one, so just up to $250, which is a standard hourly rate in the Atlanta area for this type of work. And I think these numbers are reasonable. I don't see anything that sticks out, extra work or anything that we did on this one.
Okay, thank you, Mr. Bell. I have taken a look at the file. It does appear that service was accomplished on December the 2nd. More than 45 days have passed since then, and there's been no answer filed. Ms. Shahid is in default. The dollar amounts that were submitted appear to all be documented, including for attorney's fees. And so we will go ahead and get your proposed order on file for you, Mr. Bell. Okay.
Good.
Thank you. And if we could move along to Rivermont Community Association versus Rashun Gaddy.
Exact same situation, Judge. The only thing different is that instead of a regular complaint, we actually filed a foreclosure complaint. So instead of 10 hours of work, it was 11.3 hours of work. Like on the last one, I did all the legal work on this other than just the complaint. So 195 to 325 hours, which again is standard in the Atlanta area for this type of work. I will say that the submitted proposed order, I've got a new one from Mr. Freehoff. When I was reviewing everything this morning, realized that we did not include the foreclosure language in that proposed order. So I've got a new one. I could submit it to Mr. Freehoff as soon as I get off.
That would be very helpful, Mr. Bell. Thank you very much. Okay, and so as I said, I also reviewed this file. It appears to me that service was accomplished on December the 8th, according to the record. More than 45 days have passed since service was accomplished. And so Mr. Gaddy does appear to be in default, and the amounts that have been presented seem to be documented based either in the complaint and or in supporting documentation provided by the association, including attorney's fees documented by Mr. Bell. So if you will submit that new proposed order that includes the foreclosure language, we will get it on file for you, Mr. Bell.
I will, Judge. Thank you. And that will conclude my business, if I may be excused.
Yes, sir. Have a good day.
All right, thank you. I'll take care.
Thank you, you too. D&M Associates. I think Mr. Basil had joined us. Is that right? Sir, you're muted.
Yes, sir. Yes, ma'am. I'm here this morning. Thank you.
Okay. So, Mr. do I have anybody here on behalf of the defendant, Liberty Assets, or the tax commissioner?
Well, the tax commissioner, Your Honor, has entered into a consent order that the court.
Right, I saw that.
Right.
Sometimes they still appear, though. It just depends on who the lawyers are. So, Mr. Basil, can you do me a favor and just sort of walk me through the status?
Yeah, this is a conventional quiet title, Your Honor, arising out of a tax sale where the former defendant in 5A was Liberty Assets. And I believe either incohate or a active lien was on the record prior to the tax sale held by the tax commissioner. We filed and served, let's see, according to the rule 15, we filed the, and I notice on my rule 15, I have something that's incorrect on there about the time of the filing of the suit, but we served the tax commissioner on December 21st and served Liberty Assets, attempted to serve them, and then we had to serve them through the Secretary of State, because they did not hold or keep the registered agent at the office that was designated by the Secretary of State. So we served the Secretary of State on or about January 10. We filed a certificate with the court on that, and we filed our
Motion for default judgment.
and we filed the tax commissioner did file an answer on January 20th. We're able to get the court to sign an order on the 23rd. It's just kind of what we have as a standard order between the new owner and the tax commissioner, where they recognize that the barment is correct, but that we're not barring anything that's post-tax sale.
Okay.
And we did file our motion for default on the 27th.
Right.
And we have filed with Mr. Freehoff a proposed order.
Okay, Mr. Basil, my only concern is that based on the effort to serve on January the 4th, and then the subsequent effort to serve through the substituted service on the Secretary of State on January the 10th, that 30 days have passed, and so they are in default, but a default judgment wouldn't really be appropriate until 15 additional days have passed since they went into default. And I have some concerns that actually hasn't occurred yet. And although I understand, given those circumstances, it's incredibly unlikely that Liberty Assets is going to appear and suddenly move to open default as a matter of right. What I think that I will do is, if you have provided us with a proposed order on the default judgments, we will wait and enter. I mean, everything you've presented appears to be in appropriate order, but we will wait and enter it on the 16th day after default occurred, which most conservatively, if substituted service on the Secretary of State occurred on the 10th of January, would be tomorrow plus 15 days would likely be the end of the month.
I agree with Your Honor.
And so what we will do is hold on to that motion, the proposed order that you've submitted, and we will not enter it until such time as there is that 15 days has passed. Okay.
Yes, ma'am.
Okay. Anything else, Mr. Basil?
No, ma'am. That's all.
Okay.
May be excused.
Yes, sir. Thank you. Have a good day.
Thank you, ma'am. Bye.
And Mr. Wagner and Ms. Hughley. Okay.
Yes.
So, Mr. Wagner, can you just sort of briefly walk me through the basic background, how the excess funds came to exist, and the nature of the interests, the attorney's fees claimed by the sheriff, and the nature of the interests claimed by the state of Georgia and or FSB, the other claimants?
Absolutely, Your Honor. So on November 6, 2012, the sheriff held a non-judicial tax sale for property in Fulton County with a street address of 5224 Brittany Trail. The property ultimately sold to a company by the name of Elmira Capital for a total of $10,000. At the time of the sale, Ms. Hughley was the owner of the property. The amount due on the tax sale was $1,787.63, which resulted in excess funds in the amount of $8,212.37.
Okay.
At the time of the sale, Ms. Hughley obviously had a claim as the owner of the property. Wilmington Savings Fund Society was the security deed holder is the security deed holder currently through a assignment that was recorded after the sale. And then the state of Georgia had a tax lien on this property, which was recorded in the Fulton County Land Records at Lien Book 5335, page 454. The Department of Revenue for the state of Georgia filed a claim in this case in the amount of $2,317.57. And the sheriff has incurred attorney's fees and costs in bringing this interpleader action. Our office has an arrangement with the sheriff where we charge a flat fee of $2,500 in attorney's fees for preparing these interpleader petitions from beginning to end. And there have also been costs of $905.50 incurred, and those consist of a title exam of $476.50, service of process fees in the amount of $279. And because our title exam was a little outdated by the time this action got filed, we had an updated exam done in the amount of $150. There actually should be a court filing fee included in that, but it's not on this bill, so I'm not going to ask for it. So the total amount in attorney's fees and costs that would be due to my office would be $3,405.50. If I'm doing my math correctly, taking the excess funds of $82,1237, subtracting the my office's fees and cost of $34,0450, the Department of Revenue's claim of $23,1757, there would be a remaining amount due to Ms. Hughley in the amount of $2,490.30.
Okay. Okay. Ms. Hughley?
Yes, Your Honor.
So now would be your chance to talk with me about anything to do with this matter that you wanted to address. So this is, I'm sure you understand, but I want to walk through it just a little bit. What Mr. Wagner outlined is that there was some excess funds that were generated by the Sheriff's Department in the amount of $8,212.37. There is a claimant, the state of Georgia, who has asserted a claim for $2,377.57. And the Sheriff's Department is asserting a claim for $3,405.50, which are the costs and fees associated with their filing of this action. And then that would leave, definitely not math person, and I don't want to say a number because I'll have it wrong, but that leaves about $2,000 that would go to you as part of this order under what Mr. Wagner has proposed. And so now I wanted to give you an opportunity to respond, Ms. Hughley.
Yes, Your Honor. Thank you. I was mainly concerned because about when I was served the papers, I thought that they was trying to take my home because I know I had redeemed the title to my home. And so as Mr. Wagner said, that it's probably right. I had got me a legal aid lawyer, but she said she didn't come to court and stuff. So from what, I'm mapping out, he's, I'm not fighting, against that. My main concern, Your Honor, was I thought that my home was going to be taken from me.
Yes, ma'am. Okay.
So,
Mr. Wagner, can you reassure Ms. Hughley on that point, sir?
Yes, I actually spoke to her when she was served, and I'll reiterate, Ms. Hughley, this is not a action to take your house. We're actually trying to give you money as a result of the previous tax sale. So your home is not in danger of being lost, and you're actually going to receive a check from the previous foreclosure where you redeemed your property. So rest assured, your house is not going anywhere.
Thank you, Mr. Wagner.
yes, sir.
Go ahead, Ms. Hughley.
Yes, Your Honor. I appreciate you giving me the time to talk, and I do know that I do owe the state of Georgia, and I don't have no problem with them taking the money. But I had made a payment arrangement for them to take out of my Social Security check $71 a month, and they were satisfied with that. And I just with this paper that was served, I just found, throughout all this that they had a lien. I didn't even know that because I guess I made the payment arrangement, but they've been taking $71 every month out of my Social Security check for me to, to get the balance paid up.
Okay. Mr. Wagner, is the state of Georgia documentation, is this the same account? And do you know if it includes credits for any payments that Ms. Hughley has made in the past? Not that it's your problem, but.
It looks like it does, Your Honor. The
Okay.
original tax lien was for $3,152.51, and their claim was for less than that. So I believe they're crediting what they've received from her.
Okay. Thank you, Mr. Wagner.
Yes,
Ms. Hughley, unless you have any other questions or concerns that you want to share with me, my intention is to ask Mr. Wagner to prepare an order that would outline all of this. And it would say, that there was a sale, a non-judicial sale that generated this amount of funds, and that authorizes the sheriff to retain the funds that were outlined by Mr. Wagner associated with the costs and fees for the sale, that allows the state of Georgia to be paid that $2,377.57. And then the remainder would be paid to you. And I would just need an address. And I don't necessarily want you to give me that address over Zoom right now. But what I would like for you to do is perhaps to call Mr. Freehoff, my staff attorney, or if you have ready access to email, and make sure that we have the address to mail that check to you. Is that okay with you, Ms. Hughley?
Yes, Your Honor.
Okay. Okay.
Your
Well,
Honor,
then that is.
I'm sorry,
Yes,
Your
sir.
Honor. I believe Ms. Hughley still resides at the property. Is that correct?
At the property. Is that right?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Okay. Well, that makes it easy then. So, Mr. Wagner, I have sort of a standard order. Basically, it says all the background, and then it basically says, based on all that, I hereby order the following, and it's that the clerk shall accept the money, and that once the money is paid in, you guys are released, and that the clerk shall then pay out the money in the following amounts. And it'll be separate paragraphs for each one of those. So if you could send us something like that, I would appreciate it, and we will get that order on file for you as soon as you get it to us.
Yes, Judge. I'll have that to you before the day's over.
Okay. Thank you, Mr. Wagner. Have a good day. Thank you, Ms.
Thank you,
Hughley.
Judge.
Have a good day.
Oh, thank you, Your Honor. God bless you.
Okay, so I think that leaves just the Crayla Bryce matter. And if you find counsel would give me just a moment to get some more coffee, I will give you my undivided attention and we'll get started. Thanks. Okay, I have more coffee. So if you guys are ready to get started, we can get started. So I have reviewed the file last night, including reviewing the motions that are pending. Obviously, we need to address the motions for summary judgment that are pending. But I'm also curious about the parties' positions on the motion to bifurcate. Now, obviously, if I were to grant summary judgment to any or all parties, right, that would obviate the need for the bifurcation. But I am curious what everybody's position is on that. Because I think, as I understood the position of SSA assets, that no one actually requested a jury trial, or at least not an active jury trial demand currently, except for the third party defendant whose claim is derivative. And that theoretically, if everybody wanted to go forward with a bench trial, then the court could resolve the underlying issues and determine whether or not, and depending on how they were resolved, that might obviate the need for the jury trial with the third party defendant, Sawaya Bryce. What?
Your Honor,
yes,
we would be requesting a jury trial. I've given it some thought and consideration, and I wasn't the original attorney representing the defendants, so I'm not sure if a jury trial was requested in their answer, but we would like a jury trial.
Okay. So here's so I know Ms. Claire represents Georgia Property Tax Solutions and Ashley Hayes. I know that Mr. Obaseki is representing Ms. Krayla Bryce. Is that correct, Mr. Obaseki?
That's correct, Your Honor.
Okay. And then I have Mr. Barton representing SSA assets. Is that right?
That's correct, with Mr. Morris.
Okay, with Mr. Morris. Thank you. Could somebody tell me, so I see that Ashley Hayes is on the call and I see that Alan Pendergrass is on the call. Mr. Pendergrass is still a party, as far as I'm aware. Am I correct in understanding that Mr. Pendergrass still remains unrepresented?
No, I'm representing Mr. Pendergrass.
Okay, Ms. Claire, I apologize. I, for some reason, thought you represented the company and Ms. Hayes. I don't know that I realized that you represented Mr. Pendergrass as well.
I think the only party, Your Honor, that was previously believed to be represented, but then was unrepresented was Chandra Scott.
Right.
And she just hasn't been involved in the case at all.
Okay.
I think Sawaya Bryce initially was pro se, but then retained counsel. But that's everybody else is represented.
Okay. Thank you very much, Mr. Obaseki. Okay, so since it doesn't look like we're going to get anywhere on the motion to bifurcate, then we might as well go with the summary judgment motions. Forgive me for not knowing off the top of my head which one was filed first.
I believe ours was filed first, Your Honor.
Okay, so then I will hear from the plaintiffs first. I obviously suspect there's a great deal of overlap. But sometimes it's very helpful for me to try to keep them as separate as possible because the standards to apply are different standards. And so it's helpful to me, particularly when I've got a plaintiff moving for summary judgment to focus on that. So anyway, go ahead, Mr. Obaseki.
If I can have just a moment, Your Honor.
Sure.
I'm sorry, I'm having some technical difficulties. Okay, can you hear me, Your Honor?
I can.
Okay, thank you. May it please the court. So, as the court's well aware, this case has been ongoing for quite a while. The basic facts of the case, just to go over them again, is our client, plaintiff Crayla Bryce, is the owner of 1045 Lawton Avenue in Atlanta, Georgia, 30310, from October 26, 2012. The property was essentially purchased with money from the Bryce family. So the money used to purchase the property was purchased from several different people, but Crayla Bryce was listed on the deed as the owner of the property. Her mother, Sawaya Bryce, lived at the property and has been living at the property for some time. Sawaya Bryce had a motor vehicle accident some years ago, and essentially the family was trying to make sure that she was comfortable. And so she's been living at the property. My client, Crayla Bryce, lives and has been living at all times relevant in Boston, Massachusetts. Sometime around 2019, it appears, I believe May or July, Mr. Alan Pendergrass and my Sawaya Bryce began a relationship. It's my understanding that initially it started off as a business relationship that ultimately turned into a romantic relationship.
So, Mr. Obaseki, forgive me for interrupting you, but I have dealt with this case a fairly good bit in terms of the lien holders being substituted in and out and some other issues. And so I've reviewed the complaint. I feel fairly confident that I'm familiar with the historical context in which, you know, the nature of the relationships going back and forth. And I only cut you off because unless you believe that some of those facts are particularly relevant to your motion for summary judgment, I don't know that we really need to rehash how Sawaya Bryce came to be associated with Mr. Pendergrass, because I'm sort of familiar with how that happened and then how the property came to be mortgaged, et cetera. And so maybe we could save ourselves some time in that regard. But if you believe that they're particularly material to your motion, then I certainly understand and give you that right. But if they're not, I think we can dispense with some of that.
Understood, Your Honor. So just to get to the, I think, pertinent facts, there was a business relationship as well between Sawaya Bryce and Alan Pendergrass. At some point, there was some discussions between them. We're not completely privy to those discussions about the property, but the most important material fact is there was a transfer of the property that did not involve Crayla Bryce, my client. From the deposition testimony, all parties agree Crayla Bryce was not present when the transfer was signed. I believe Ms. Hayes and Mr. Pendergrass testified during their depositions that they never actually had any direct contact with Crayla Bryce regarding the transfer of the property, that they believed for whatever reason that Sawaya Bryce had the authority to transfer the property. The signature on the transference is allegedly purported to be the signature of Crayla Bryce, who was not present by all accounts at the time. There's not a signature saying, you know, Crayla Bryce authorized by Sawaya Bryce or anything to that effect. Obviously, there is some dispute amongst the defendants, Ms. Sawaya Bryce, as well as the Georgia Property Tax Solution defendants, that who signed the deed. The only thing that is not in dispute is that Crayla Bryce did not sign the deed, and that there was nothing in writing whatsoever from Crayla Bryce authorizing the transfer of her property to Georgia Property Tax Solutions. In fact, Georgia Property Tax Solutions as an entity did not exist until I believe several weeks after the transference of the property. The Secretary of State's documentation shows that they weren't actually that documentation wasn't submitted to have them as a legal entity until about 15 days after the alleged transfers. And so we submit, Your Honor, that based on that documentation that we actually have, there is no authority given by Crayler Bryce to anyone to transfer her property. There's some alleged speculation that she had to have given authorization to Sawaya, but there's no testimony of that in depositions, and there's definitely nothing in writing suggesting that. The only thing that is 100% clear and undisputed is Crayler Bryce did not sign that document. Nobody from the Georgia Property Tax Solutions defendants, Alan Pendergrass or Ashley Hayes, talked to Crayler Bryce or asked for her authorization. Alan Pendergrass specifically is an experienced real estate professional, or had been at least previously, and knew or should have known that had he required the authorization of Crayler Bryce, he would have needed something in writing from her saying that she had the authority or was giving her authority via power of attorney or some other legal document for somebody else to sign on her behalf. None of that is present in this case. Crayler Bryce was completely innocent, living in Massachusetts at the time of this. Subsequent to that, there was loans taken out, I guess, to renovate the property. Some of that money was used to renovate the property. Some of it was used, presumably, to pay Mr. Pendergrass and I guess Sawaya Bryce and maybe Ashley Hayes a salary for whatever they were doing on the property. Additionally, the documentation that we have suggests that obviously not all of that money was used towards the payment of renovations toward the property. So, Your Honor, primarily what we've sought is claims for quiet title, fraud, punitive damages, and attorney's fees. Obviously, forgery. I think the forgery is clear here that Georgia Property Tax Solutions, Alan Pendergrass, Ashley Hayes, and presumably Chandra Scott, for whatever reason, somehow decided that they were going to take this property from Crayler Bryce without her permission, without her express authority. They signed a document, had somebody, it's still, again, unclear as to who notarized the document, although Sawaya Bryce's name is listed as the notary and Chandra Scott's name was listed as the witness to Crayler Bryce signing it, although Crayler Bryce clearly didn't sign it. So just based on the face of the document, as well as the admissions by the parties, there is a forgery there. Whether or not that forgery was committed by Georgia Property Tax Solutions, Ashley Hayes, Alan Pendergrass, Chandra Scott, Sawaya Bryce, does not matter legally. The only thing that we submit matters legally is that Crayler Bryce did not authorize that transference. And that transference also is invalid because it's transferred to an entity that did not exist at the time of the transference. Under the circumstances, there is, I think, clear evidence of forgery. These are undisputed facts. And by virtue of that forgery, the case law is clear that the transference would be null and void. Because the transference would be null and void, quiet title should also go to Ms. Bryce, Crayler Bryce, against all of the parties. That includes all the assigned mortgagees, going from MoFin Lending, which was the initial lender, down to SSA Northeast Assets LLC. There was an additional alleged mortgage from Urban Capital Alliance, which is a company that was organized by Ashley Hayes, who through her deposition testimony admitted that she took out that there was never an actual transference of $499,000, which is what that security deed shows. There was never a loan for $499,000. She was upset because whatever alleged deal happened between her and Alan and Sawaya Bryce. And so she essentially took out this fraudulent security deed for Urban Capital Alliance, which is illegitimate on its face also. For all those reasons, Your Honor, there's also obviously, punitive damages that we've asked for. I think under the circumstances when there's clear fraud and forgery, both from the initial transaction as well as the subsequent alleged security deed from Urban Capital Alliance. There's also very clear intent to create this, slander of title and fraud against Crayla Bryce. Now, we would ask the court to consider all the evidence that's undisputed and take that into consideration in finding that there should be summary judgment at minimum for Crayla Bryce to receive quiet title, and that there is sufficient evidence to show that there was not any authorization granting any authority from anyone to have this transference go through.
Okay, thank you, Mr. Obaseki. Ms. Claire?
Thank you, Your Honor. So I think what the plaintiff is failing to state when it comes to the facts of the matter is that Soraya Bryce had a big part in this title transfer. In addition to that, her and her daughter, Crayla, talked very often and were in communication about what was going on, even though Crayla was not in Atlanta. She talked to her mother about what was going on with the property. And it's our position that Crayla authorized her mother to sign the deed, and she was the actual person that signed the deed, transferring the property to the property tax solutions. So our position is that, if that was fraudulent, if Crayla did not authorize that signature, then that's fine. We're perfectly fine with giving back title to Crayla. However, we think that she or Soraya should pay damages in the amount that they have been unjustly enriched or benefit from the renovations that the property did take on, as well as the taxes that the loan paid off on the house. So that is our position on the plaintiff's motion for summary judgment regarding title. As far as their other claims for punitive damages and attorney's fees, we are aggressively contesting or objecting to those summary judgment on those counts. The plaintiff's motion for summary judgment on punitive damages stated that it should be awarded because it's a tort action. They actually cited OCGA 51-12-51, which is punitive damages and tort. This is not a tort action. This was a action that sounded in contract law, the sale of real estate. And punitive damages are not allowed under Georgia law in contract matters. That is pretty standard law. So we're definitely objecting to any summary judgment on punitive damages. The defendants for Georgia Property Tax Solution, Ashley Hayes and Pendergrass, don't show any willful misconduct, malice, fraud, or wanton oppression to justify punitive damages. They were also a victim to the actions of Soraya Bryce, a third-party defendant, which we find is pretty weird that Crayla filed suit against all of the other defendants, but neglected to file suit against her mother, who actually forged her signature. So we are asking the court to find that there shouldn't be any summary judgment regarding punitive damages, and that should, if anything, be a decision that the trier of fact makes. They've also asked for punitive damages on attorney's fees. Attorney's fees or expenses of litigation are generally not allowed, unless the plaintiff has specifically pleaded and has made prayer before, therefore the defendant has acted in bad faith or been stubbornly litigious. That is not the case here. My clients have not acted in bad faith or been stubbornly litigious. There was never any type of demand or even request to resolve this matter before suit was filed. They were just hit with the lawsuit without anyone ever reaching out and saying, hey, can we just transfer the title back? And resolve this without litigation. And so we are asking the court to find that summary judgment is also not proper on the fact of attorney's fees.
Ms. Claire, let me ask you a question on the issue of the alleged forgery. I think I understand Mr. Obaseki's argument on behalf of Ms. Bryce to be that even if there is some dispute as to how Crayla Bryce's signature came to exist on that deed, there is no dispute that it's not Crayla Bryce's signature. So if there's no dispute that it's not Crayla Bryce's signature, then how is it not per se a forgery?
Well, it wouldn't be a forgery if she actually authorized someone to sign on her behalf.
And so your argument is that there is a dispute of fact as to whether Sawaya Bryce had Crayla Bryce's authority to sign the document?
Correct.
Okay, and what evidence indicates in the record that who has said or testified or otherwise that Sawaya Bryce had Crayla Bryce's permission to sign her name to that deed?
I don't think there's any direct testimony of that nature. The only thing that we have is emails or text messages between the two, Crayla Bryce and Sawaya Bryce, as well as just the previous fact showing that Sawaya Bryce is the one who actually purchased the property. She had the dominion control over the property, everything that an owner does.
Oh, don't get me wrong, Ms. Claire. I have teenagers, and as they would say, this all is sus, right? This sounds real sus. I agree with you on that issue, Ms. Claire. But on a summary judgment motion, what we're looking at is record evidence. And the fact that you could or intend to ask a jury to question the nature of the relationship between adverse parties, the mother and daughter here, that's a separate matter than whether there is record evidence one can point to that Ms. Bryce had authority to sign on behalf of, Sawaya Bryce had authority to sign on behalf of Crayla Bryce. But anyway, go ahead.
Well, Your Honor, and just being frank and candid, it's very unlikely with a mother and daughter pair that we're going to have that direct evidence. And that's really the only
Have they not been deposed in this case?
They have.
Okay. And Ms. Crayla Bryce, I know, says not her signature, right? That part is clear. Everybody seems to agree. Crayla Bryce, not my signature. What did Ms. Sawaya Bryce say in deposition about that signature and how it came to exist on that deed?
She says that Alan Pendergrass is the one who signed the signature. However, we have submitted evidence from our expert handwriting, our handwriting expert, that it was actually the signature of Sawaya Bryce.
Okay. Thank you, Ms. Claire. Anything else in response on behalf of your clients to the summary judgment motion?
No, Your Honor.
Okay. Mr. Barton?
Yes, Your Honor, may it please the court. I have a procedural point and a couple of substantive points that I'll offer on this issue. The procedural point simply is that the motion as filed is not supported by any admissible evidence. The motion as filed was supported by and referred only to pleadings filed in the case, the complaint, the answer of GPTS, neither of which is a verified document. And so from the get-go, the motion suffers from the defect that it's simply not supported by any evidence. The plaintiff never made a motion under Rule 6B to add any evidence to support their motion. And so the motion is defective right out of the starting block. As it relates to the substantive points from our client's perspective, of course, we weren't there. We're an innocent lender. We simply provided funds to pay off liens on this property and renovate the property. I think it is fair to say that there's no dispute that Crayla Bryce did not write her name on the deed. I think that's fair, but that doesn't make it a forgery necessarily. There's abundant evidence, particularly when you construe all of the inferences in the case away from the plaintiff and in favor of the defendants in this case, and particularly the innocent defendants who were not even present, that Miss Bryce's mother was invested with general authority over this house. I would ask the court to consider the following things. First, this property, which was purchased as an investment property for the family in general. It was purchased with funds that were wired from Miss Bryce's mother's account to the closing lawyer. So in other words, Sawaya Bryce paid for the house. There's evidence in the record that Miss Sawaya Bryce didn't want the property in her name because she had Social Security benefits that she didn't want to have impacted.
Right. I remember those facts. We discussed them previously, that she was perhaps either applying for or receiving disability benefits, and that would be an asset that might potentially be touched if it was in her name. I understand. I'm not saying that's true, but I understand that there are some facts in the case regarding that issue.
At least if you construe the inferences, that's correct, Your Honor. And then you have just what occurred over the next 10 years or 8 years, I guess, or so, until the deed was signed. And that is that the plaintiff didn't reside in the house, didn't pay the bills. The mother paid all the bills. The mother handled everything relating to the house. And so in our view, the mother had just general authority over the property, which was, again, an investment for the family, at least if you're construing the inferences in the defendant's favor. And then the second substantive point is that even if there were a forgery here, a forgery doesn't make a document void, it makes it simply voidable. And there is abundant evidence in the record that as the property was being handled, renovated, et cetera, by the mother, which again, we believe the evidence showed the mother had the authority to do, that Crayla Bryce, the plaintiff, was aware of it all as it was happening. She was looking at pictures and videos of the renovations as they were occurring. She was seeing the progress on the property. She was responding to social media posts, et cetera. And so we believe that there is at least enough factual inference from the record in the case that must be construed away from the plaintiff in favor of the defendants on the issue of whether Sawaya Bryce, A, had authority to sign in the first place, or B, whether Crayla Bryce ratified everything that was happening with this house as these renovations were taking place with my client's money. And so that's essentially our position on the forgery issue. Unless Mr. Obaseki tells me I'm wrong, I don't believe the punitive damages claims or the attorney's fees claims are asserted against my client, so I won't address those unless he corrects me. And then lastly, and this bleeds over into our motion, and I'll leave the gist of it until the court calls on me to address it, but to the extent the plaintiffs are seeking to have the court declare that they are the fee simple property owner of this property without any liens, there are, of course, substantial issues in the case relating to equitable subrogation and equitable liens that are the subject of our counterclaims and defenses that obviously would impact the title to the property, regardless of what the court might ultimately find on the forgery question.
Right, and that's that equitable lien and other matters that are the subject of your summary judgment motion and your claims and responses and counterclaims.
That's correct.
Okay, thank you. Mr. Obaseki, it's your motion, so I'll let you have the last word, sir.
Thank you, Your Honor. Your Honor, much has been made by Attorney Barton about this quote unquote general authority. If I let somebody use a car that I purchased, that does not make it no longer my car. The same is true for a house. In this particular case, we're not talking about allowing somebody to live there. We're talking about transference of ownership. It doesn't matter where those funds came from. Crayla Bryce was the legal owner of that property. And there's testimony from Crayla Bryson depositions that some of the money that was used from Sawaya Bryce was actually money that was owed to her because they had been taking care of her while she was, sick after having the accident. So essentially, some of this money is being money paid back. But again, I think that's somewhat of a red herring because at the end of the day, we have legal owners on title for a reason because they are the people authorized to transfer the property. And there's nothing anywhere other than mad speculation, which is not enough to overcome a motion for summary judgment. There needs to be facts in the record showing there's a genuine dispute of material fact. Here, what you've been presented with is speculation from Ms. Claire's client as well as Mr. Barton's clients that maybe Crayla knew what was going on, but there's no evidence of that whatsoever. The only evidence that's clear and undisputed is that Crayla Bryce did not sign the transference to Georgia Property Tax Solutions, that from the depositions, neither Ashley Hayes, Alan Pendergrass actually ever talked to Crayla Bryce to get her authority or to verify her authority before the transference.
So, Mr. Obaseki, I'm sorry, let me interrupt you for a second because I'm not sure I buy that last part you mentioned. So you're telling me that there is no evidence in this case that Crayla Bryce knew that improvements were being made to her house over a 9 or 10-year span?
What I said was there's no evidence that Crayla Bryce knew about a transfer of the property to
right, but
now,
and I may be straying into the other summary judgment motion, but if there's evidence that Ms. Bryce, as the owner of the house, had knowledge that substantial improvements were being made, then can't a logical inference from that, which is fair for purposes of summary judgment, et cetera, for evidentiary purposes, can't a logical inference be made from that she had to have some knowledge that there were funds being used? And I mean, somebody was paying for those improvements to her asset.
Right, and we don't dispute that she had knowledge that somebody was paying for those things. I'm primarily right now talking about the transfer of the property, the quiet title action, because we have different actions here, right? That could be addressed, we believe, appropriately.
No, I understand.
The first being the transference of the property, the forgery, the quiet title action. The second being the knowledge of the renovations. There is evidence from the depositions that she knew, obviously, that there was renovations happening to the property. I mean, her mother was posting about it on social media. She was aware. She was not aware of where the money was coming from because, again, she had nothing to do with that. The mortgage taken out from OFIN Lending, the lender at the time, had nothing to do with Crayla Bryce. It had everything to do with Georgia Property Tax Solutions because Georgia Property Tax Solutions personally guaranteed that loan. She would not have known or been aware of where that money came from because she was not privy to any of that. She was privy that there was renovations happening to the property. We don't dispute that. She later subsequently became privy that some liens on the property had been paid off by the funds. We don't dispute that either.
Okay.
But
forgive me for interrupting again, Mr. Obaseki, but I think I understand Mr. Barton. Part of Mr. Barton's point is that even if it's undisputed that Crayla Bryce's signature is that she did not put her signature on that document, right, on the deed, that it was either Sawaya Bryce or it was Ashley Hayes or Alan Pendergrass or someone, that doesn't necessarily make it a forgery if there's evidence or disputed evidence from which someone could find, number one, that Sawaya Bryce or whomever signed the document had the authority of Crayla Bryce. That's number one. And number two, that even if it was a forgery at the time, that forgery can be ratified by subsequent behavior of Ms. Crayla Bryce, for example, in acquiescing to funds being spent to improve the property that she owned.
Right, but I think that also makes a huge assumption that she knew where the funds were coming from, and that the funds were coming from a transference of the ownership of the property. And that's, I guess, what I want to make sure that I'm clear on with the court. Just because she was aware that renovations were happening and that renovations had to have been happening from some money does not mean that she was aware that the money was used from a mortgage taken out against her property after the ownership of the property had been transferred to a third party. So
no, and fair enough, Mr. Obaseki. Here's my last question. What happens to the SSA claims if I were to find that what happens, and I don't mean legally their claims, I mean the dollar amounts legally their claims and as well, but what happens to their claims if I agree with you and say, as a matter of law, there's no dispute that that was a forgery?
As a matter of law, if there's no dispute that that was a forgery, I
Yes,
think
sir.
the client would go back to Ms. Crayla Bryce, and there would be a contract dispute between SSA, Northeast Assets LLC, and Georgia Property Tax Solutions, and specifically Ashley Hayes, because she personally guaranteed the repayment of the loan.
But what about the windfall to Crayla Bryce, to this, wonderfully improved house that she gets free and clear with zero mortgage?
Well, in terms of the improvements, there's some dispute there about how much money was actually used to improve the homes and actually the level of improvements. I mean, we viewed the property, some of the improvements were very poorly done and likely would need to be redone. So we don't necessarily dispute that there were improvements to the property, but in terms of the value of those improvements and how much of that money actually went to those improvements, we quite honestly don't know what those are right now, because again, Mr. Pendergrass was paying himself apparently from those assets. Apparently some of the money was going to other parties as well. We don't know exactly how much was going and how much was actually spent towards the renovation of the property, and whether or not it actually added any value or if it will now need to be redone. We admit, and I've spoken to my client regarding the liens that were paid off. We don't dispute those amounts. I believe that equals up to about $7,000, which is for taxes and I think overdue utility bills. But everything else would still be in dispute because again, we don't know exactly how much was actually used towards the renovations or the value of those renovations.
Okay. Thank you, Mr. Obaseki.
Your
okay.
Honor, Your Honor, if
yes, Mr. Williams.
I'm sorry, may I just add another small piece to that?
Hang on one second, Mr. Williams. You represent Ms. Bryce, is that right?
Yes, Attorney Obaseki and I are co-counsel.
Okay. The only reason I say that is I usually don't let everybody double team, but if it's real quick, then go ahead, Mr. Williams.
It's really, really quick, and I just want to make a really essential point. I think Attorney Obaseki had pointed out that at the time of the transfer, that the entity that the property was transferred did not exist. So we believe that it's also important that the lender takes some accountability for their own negligence that resulted in them issuing a loan, that had they done the due diligence to investigate the entity itself and the transfer itself, they could have easily learned that that entity could not have possibly received ownership of that property through the conveyance because it was not in existence at the time. I believe that there was sufficient evidence in the records of the courts that would have alerted them to there being some potential issue here and could have investigated it further. And finally, Your Honor, when you ask about their recourse is against the very people who committed fraud against them, which would be the parties who were involved in fraudulently signing Crayla Bryce's name to the document, taking out a loan that was fraud. We know that this is not the first time that those defendants have engaged in this type of activity. We understand that it's part of the motion in limine, but we think it's very relevant that the individuals involved have done this to others before, and that
Well,
cannot.
let me stop you for just a second there, Mr. Williams, and just say this. On summary judgment, the court is only supposed to consider admissible evidence. And although there's a universe in which y'all could argue and maybe demonstrate to me at trial that that information might be relevant for some purpose other than character, that foundation has not yet been laid. And so I'm not taking into account the allegations of prior criminal behavior by any of the parties in the case.
Fair enough. And I appreciate that and definitely understand that. But finally, what I would offer is that it is without question that the lender had access to records that would have called into question the loan itself, the issuance of the loan itself. And neither their negligence nor the fraud perpetrated by those responsible for the fraudulent transfer, neither of them can benefit from that behavior. And therefore, Mr. Barton's client, his recourse would be against Georgia Property Tax Solutions and those who guarantee that loan. This property is not the only source of recourse for this loan that is now in default. It is those who guaranteed it and those who took it out. And I appreciate Your Honor for allowing me that small, brief opportunity to speak.
Okay, thank you. I whenever lawyers use the word brief, I'm always reminded of the quote from Princess Bride. You keep saying that word. I don't think it means what you think it means. And it's not just you, Mr. Williams, it is universal among lawyers. But in any event, thank you, Mr. Williams. What I'd like to do, because again, as I said, I wanted to keep them separate, but I think that the issues overlap substantially, to now hear from SSA on their motion for partial summary judgment, and then have the parties respond on those issues. Mr. Barton?
Yes, Your Honor. Thank you. Very briefly, our motion is discrete and it only hits 3 separate points. And I think the first one, I heard Mr. Obaseki concede that we're entitled to be equitably subrogated to the prior lien positions that we paid off. I mean, this house was regularly behind on its tax bills. Tax bills were being bought and sold pretty repeatedly on this property over the years. And part of the loan proceeds, almost $7,000, went to pay those existing liens. And under the Davis case that we cite in our brief, the lender is entitled to be equitably subrogated to that first lien position. As it relates to the equitable lien, and that would concern primarily the improvements that were made, I concede the point that Mr. Obaseki made that those matters in terms of the amount of them are subject to proof. They're subject to proof in terms of how much money was spent and or what the value increase was as the result of the injection of the loan proceeds into the renovations. But the entitlement to a lien itself, just sort of the liability, as opposed to the damage part of it, I guess is my point. I think there's no question we are entitled to that. And then lastly, and this is really Mr. Morris's part of the case and not mine, but I don't think there's really going to be any dispute on the suit on the note and the guarantee that was signed by GPTS and the guarantee signed by Ms. Hayes. Everybody acknowledges that the documents were signed, the loan proceeds were paid and used, and I think ultimately the amounts that are owing are going to be undisputed. So I'll defer to him if there's anything in addition to that that needs to be covered, but I think our motion, frankly, is pretty self-explanatory on those points, Your Honor.
Okay, thank you. Mr. Morris?
Your Honor, good morning.
Good morning.
I don't have much to add other than what Mr. Barton said. It is pretty self-explanatory in our motion. I think all the parties here have kind of agreed that the recourse against GPTS and Ms. Hayes as the guarantor, regardless of all other claims, are viable and have teeth. These are probably the least suspects that we have in this matter. There's no dispute. There's deposition testimony that they entered into these contracts, the note and the guarantee. Ms. Hayes, in her deposition, states that she defaulted on the notes. There's really no issue at all that our client was damaged through this breach, and therefore under Georgia law, we're entitled to collect on the breach of the note and the breach of guarantee, and then also, excuse me, attorney fees under 13-111, which were properly pled for in our counter or our cross claim, and they were found in the loan documents. So, Your Honor, if you don't have any questions, I believe, like I said, the brief and the documents pretty much speak for themselves as far as these three claims.
Okay, thank you, Mr. Morris. Ms. Claire?
Thank you, Your Honor. So, we are definitely contesting the so-called personal guarantee by Ashley Hayes. And I want to see if I can pull it up really quickly, because if you actually look at the note, she signs on behalf of the organization Georgia Property Tax Solutions. And so even though she signs her personal name, she signs on behalf of them. And even her deposition, she stated that she signed on behalf of the organization. So she did not personally guarantee the loan, even if it was meant to be that. She was not under the impression that she was personally guaranteeing the loan. Yeah, I'm just looking for the document. So that's our first point, that Ashley Hayes shouldn't be personally responsible for any, I guess, damages or payment to SSA. As far as the defendant SSA's cross claims on us, my clients client Georgia Property Tax Solutions do recognize that they took out the loan. They are taking full responsibility for that. They understand that the loan is owed back. Their intentions per the agreement with Soraya Bryce was to flip the property, of course, sell it, and then the loan would be paid back, because the property's value and worth is way more than the loan at this point in this current market. However, they were not able to do that because the contract with Soraya Bryce was breached, and they were not able to sell the property. They did put the property up for sale. It was listed. However, Soraya Bryce objected to showings, but she did not let the property be shown, and so they weren't able to sell the property. But they have no, I guess they're not contesting the fact that they owe the money. They know the money is owed. As far as fraudulent claims, Georgia Property Tax Solution, as well as Allen Pendergrass, they have not committed any fraud that SSA has proved. I mean, it's just based off of the facts, it's just claims that there was some type of fraud. But Allen Pendergrass is not the one who signed the deed, and it's not the one who committed fraud, nor did any member of Georgia Property Tax Solutions commit any fraud against SSA or the previous lender.
Well, as I understand it, Ms. Claire, just to sort of focus your argument, although obviously they're retaining those rights to assert those claims, the summary judgment motion that they filed, at least as it relates to GPTS and Ms. Hayes, is really only that they're asking for a summary judgment that there was a default by GPTS and by Ms. Hayes based on the personal guarantee, which I understand you dispute, and that because the note provides for attorney's fees in the event of a default, that they're entitled to attorney's fees associated with the default on the note, either or both from GPTS and from Ms. Hayes based on the personal guarantee. And so although they may allege fraud in the larger claims, I don't think that's really what they're asking for summary judgment on now. I think they would agree with you that the question of fraud is rife with factual disputes that would need to be resolved by a jury.
Okay. Well, Your Honor, there really is no way to dispute the fact that the funds are owed, and then yes, attorney's fees would also be owed. That's pretty much part of every security deed and every note that's filed here in Georgia. So there's really no way for us to dispute that. Yes, they have defaulted on the deed. They weren't able to pay it back. They did make some payments. So I want to let the court know that the payments were made on the loan monthly up until the time that Sawaya Bryce refused to allow it to be sold and this action was filed. So they made payments up until this action was filed on the note. So the amount is in controversy as far as what would be owed, but there's really no other way to contest the fact that the loan is owed back. Okay, thank you, Ms. Claire. And then Mr. Obaseki or Mr. Williams, I wanted to hear from you on the equitable subrogation issue. As I understand, their position is that there's really not a dispute that they're equitably subrogated to the property or to the liens, that the only issue is the amount of the liens and whether the entire amount of the loan that they gave would constitute part of their subrogation. What is y'all's position on that?
Well, I think, Your Honor, Attorney Williams kind of addressed to a degree the subrogation in regards to the negligence of the lenders in loaning money to Georgia Property Tax Solutions for the transfer when the entity did not exist at the time of the transfer on the face of the documents themselves.
Well, let me back up for a minute, Mr. Obaseki, because Mr. Barton started out by saying, I think Mr. Obaseki even concedes our entitlement to equitably subrogate, to be equitably subrogated, at least as to the amount of the hard liens that were paid out, and that the real dispute is as to whether and what funds that were obtained in that mortgage were actually used to the benefit of the house. So back up and tell me what y'all's position, and because if your position is, as Mr. Williams framed it, that the bank was negligent in not doing its due diligence in giving this loan, then you're not conceding that they are entitled to equitably subrogate at a minimum to that $7,000.
And I believe that's correct, Your Honor. What I was trying to say is that Ms. Bryce has indicated to me a willingness to pay the bank because those were fees that she was going to have to pay to someone anyway. But, you know, in this particular case, presumably SSA, any assets would be the people that paid it. But in terms of the renovations to the property, one, again, our client didn't have anything to do with taking out the loan for the renovations of the property. And for whatever reason, Ashley Hayes decided to hear Ms. Claire saying that she didn't know that she was doing a personal guarantee, but the documents, from my perspective, clearly state that it's a personal guarantee of the loan for her as an individual, separate and apart from Georgia Property Tax Solutions. The money was used not just for the renovations, but for other things, and it's not clear how much of the money was actually used for the renovations or for other things. And so a lien, especially under these circumstances where the allegation is a fraudulent transfer that Ms. Bryce had no knowledge of, and she obviously didn't have any privy to the contract between Georgia Property Tax Solutions and MoFin Lending at the time, now assigned to SSA any assets. She should not be essentially victimized twice by one, having her property taken out from underneath her, and then two, having to pay back a loan that another entity took out just because they may have used some of that money towards the renovations of the house that they were essentially trying to sell without her permission and authority.
Okay. Thank you, Mr. Obaseki. Mr. Barton, Mr. Morris, it's y'all's motion, so I'll let you have the last word.
Just very briefly, Your Honor, I want to distinguish between the equitable subrogation concept and the equitable lien concept. The subrogation concept concerns the prior liens. And in that instance, because we paid them in good faith, and that redounded to the benefit of the plaintiff, if she still owns the property, we're entitled to be subrogated to that first lien position, or the lien position of the liens that we paid off. That's the Davis case. The equitable lien concerns the improvements to the property. And I would disagree with Mr. Obaseki that Ms. Bryce was a victim here as it relates to those improvements. She knew they were being made. She knew her mother did not have the wherewithal to make the improvements. She certainly knew somebody was paying for it, presumably somebody other than her mother. And she stood by and allowed those improvements to be made. And so the fact of the equitable lien, I think, is and should be undisputed in a matter for summary adjudication. As I said previously, I acknowledge the amount will be something that we'll have to prove, and the increase in value, et cetera. And that's what we'll have experts for at the appropriate time. But the fact of the lien, I think, is appropriate for summary adjudication. And if I could, Your Honor, can I just address the what I consider to be a red herring issue? And I'm not sure it relates to my motions, but it may relate to the plaintiff's initial motion. And that is this idea that GPTS didn't exist at the time of the deed transfer is a new argument. And I can't cite a case off the top of my head, but I've dealt with that issue many times over the years. And it is not incumbent at all for corporations to essentially after acquire property that is deeded to them before they formally exist. Happens all the time, and be happy to address that, Your Honor, with a supplemental letter brief or something if it's appropriate. I'm not sure it's really relevant to any of the summary judgment issues that are before the court today, but I just wanted to offer, if the court wanted me to address that issue. But again, I'm not sure, frankly, that it's pertinent to any of the issues the court's considering today.
Yeah, I tend to agree with you. And I was less concerned by that issue because having dealt with single purpose real estate entities, I too am familiar with the fact that they are often created simultaneously, and sometimes the paperwork doesn't get dry until after other paperwork is done. So the one thing I did want to actually follow up with you, Mr. Barton, is, Ms. Claire had made a point about the personal guarantee. I note that it's referenced in the party's summary judgment motion as Exhibit 33 to Ms. Hayes's deposition. I can read her testimony regarding the issue, but interestingly, the exhibits aren't attached to the deposition that was filed with the court. So I can't actually see Exhibit 33, at least not attached to her deposition. I'm sure it's somewhere else in the record.
It is also attached to our cross claim. And I think what happened, Your Honor, is we used a single set of exhibits for all of the depositions.
Yes, sir.
So the exhibits may have been filed separately, but I know they were filed, or I could ensure that they have been. But the guarantee is attached, and I don't remember the exhibit number, but it is attached to our cross claim.
I'm looking at your cross claim now, so.
I guess I don't understand Ms. Claire's point. I'm looking at the guarantee, and it is made by Ashley Hayes, an individual resident of the state of Georgia, and the signature is Ashley Hayes, not a corporate entity. There are other documents also in the record that I could cite to the court where it's a borrower's and guarantor certificate of representations and warranties. This is Exhibit 35 to the deposition that Ms. Hayes acknowledged she signed. And among other things, this agreement states that guarantor shall be and is at all times while the loan remains outstanding liable for the loan and the entire indebtedness. So I guess I'm not really understanding the point relating to the guarantee. It's clearly a personal guarantee. The note obviously was signed in a representative capacity, but the guarantee itself clearly was not.
And that's what I suspected, but I wanted to look at the document itself, which I am now able to do. I'm
sorry, what exhibit are we referring to? As far as personal guarantee?
Exhibit 33 to the deposition, and I don't have the cross-claim open.
It's exhibit B to defendant SSA's answer counterclaims and cross claims filed on November the 21st, 2022.
Right. And I think, Your Honor, in the guarantee, Ms. Hayes acknowledged he signed the document. There's not a question as to her signature.
No, I understood that. And I could tell that from reviewing the deposition testimony. As I understood Ms. Claire's argument, it was that the signature itself carried some sort of limiting designation that she was signing on behalf of the corporation. And so what I wanted to look at was the actual document that she was signing, which was a guarantee separate from the other documents that she had signed. And so that's why I was asking to see the document.
And if you look at the document, Your Honor, on page 14, for her signature, right behind it, it says sole member. So she's basically stating I'm signing as a member of the corporation, not on my own personal guarantee. And I think it would be an argument of who drafted the agreement and interpretation of the contract and the personal guarantee. If someone is signing it and they don't understand that they're signing.
Right, I understand that, Ms. Claire. I think that that argument might have a little bit better weight if you were talking about the actual deed that she signed, but the second document she signed is an individual document that says guarantee. I mean, it's an entire document that says she's personally responsible for it. And so that's why I wanted to look at the documents. But I certainly understand Ms. Hayes' position. I think I understand the parties' positions on summary judgment anyway. And so I will tell you this. I started off at the beginning and I still stand by that, you know, this is sus, right? I ultimately, Ms. Bryce, through a trial, Crayla Bryce may ultimately end up being fully vindicated, and it may be demonstrated that she really didn't have any idea what was going on and that she was taken advantage of by her mother and by Ms. Hayes, Mr. Pendergrass. The evidence could also equally demonstrate at trial to a trier of fact that Ms. Crayla Bryce knew what was happening and went along with it, because then all of a sudden now we end up here and she might end up in a position to take a very valuable asset with no liens on it to her benefit. And so all of that is, the point of that is to say this. I agree with SSA's argument that although there's no dispute of fact that Crayla Bryce did not sign her name to that deed, that does not end the assessment. The assessment is whether or not it was a forgery, and if it was a forgery, was it either an authorized forgery or was it a subsequently ratified forgery? And the facts as to whether that forgery was subsequently ratified or whether it was authorized in the first instance, I think are open questions that are subject to dispute and that require a jury to determine. Although I will say this, although I'm not granting summary judgment to the plaintiffs I'm denying the plaintiff's summary judgment on the issue of fraud. I'm also denying, or forgery, I should say, the plaintiff's summary judgment on the issue of punitive damages and attorney's fees. I will say that those claims should ultimately Ms. Crayla Bryce be able to vindicate that she was taken advantage of here. Those are certainly valid and viable claims. And so I want to be clear that just because I'm denying summary judgment because I don't think they're appropriate for summary adjudication, they still live and are still there to be presented by plaintiff's counsel to a jury. Now, that that deals with the summary judgment that was filed by the plaintiff. Yes, sir. Yes, sir, Mr. Obaseki.
Quiet title. Because there's also actions of quiet title, and the GPTS defendants essentially haven't disputed that. They didn't dispute that in their answer.
Well, I don't necessarily agree with you, or excuse me, I don't necessarily disagree with you. Here's where I'm hesitant on the quiet title, is that I think the quiet title is a very broad brush. And I think what I have to understand is, if there are fact issues that leave open the question of whether Ms. Bryce, Crayla Bryce, I'm not saying this right, Mr. Obaseki, but here's my concern. The quiet title action, I am concerned if I were to grant summary judgment on the quiet title action, that it runs the risk of implying that all other claims have been extinguished, which is the purpose of the quiet title. And there is still this issue of the equitable lien, equitable subrogation, that ultimately Ms. Bryce may have title quieted at the conclusion of this matter in her favor. But I'm concerned that if I do it now, that it jeopardizes the other claims that I think also end up remaining open, which is the equitable lien matter. Mr. Barton, is that SSA's position that the quiet title is inappropriate because the equitable subrogation and equitable lien claims still exist?
Exactly, Your Honor.
Okay. So that takes care of the summary judgment motion that plaintiffs filed, which is denied. As to the summary judgment motion that was filed by SSA NE Assets LLC, let me start with the easy ones. I think I made it pretty clear. I agree that there is no dispute that GPTS defaulted on the note, and that as a matter of the operation of that note, GPTS is responsible for attorney's fees. I also agree with SSA that Ms. Hayes's personal guarantee was valid, and that she also personally guaranteed the note, and therefore she is obligated and responsible for the default on the note, and that also makes her obligated and responsible for attorney's fees under the note. And so as to SSA's summary judgment motion as to their claims for default against GPTS and against Hayes, I grant that partial summary judgment on those two claims. And I grant summary judgment to SSA on the attorney's fees claim that arise from those two defaults. As to the equitable lien, I understand the motivation for the equitable lien, and I think there probably is a universe in which a DV is granted, that there is some right that inures to the benefit of SSA for the liens that it paid. But because the dollar amount is in dispute, I fear that that again would be too broad of a brush to say, excuse me, to say that I find as a matter of law that they are entitled to the equitable lien. And although it is entirely because the amount remains in dispute, and not because of any concern that the court has about the existence of GPTS at the time that the mortgage was taken. So for that reason, I am going to grant the partial summary judgment that was filed by SSA as to the default on the note by both Hayes and GPTS and the responsibility for attorney's fees. And I'm going to deny the summary judgment as to the equitable lien because the amount of damages continues to be in dispute. And so therefore, I think I should refrain from entering even a partial summary judgment on that issue. Although, to be clear, it's entirely possible that the evidence at trial would motivate the court to enter a DV in favor assuming the evidence comes in the way I believe that it would, in favor of SSA on the entitlement to the equitable lien. And then perhaps the only issue left for the jury is to determine what is the amount of that equitable lien. But that's a matter for another day. Mr. Barton and Mr. Morris, if you could please prepare a proposed order on both of those and email them to me with copies to all counsel. Once you get a copy of that, if you have concerns that the order that's presented does not accurately reflect what I have said here today, then let me know that. But it is not an opportunity to re-argue the motion or try to change my mind. So it's just a matter of making sure that it accurately reflects the ruling that I have made.
Your Honor, are we going to address the third party requested to strike and dismiss third party plaintiff defendant Sawaya Bryce?
I was wondering, hi, Mr. Jerome. I normally see you on my criminal dockets in your criminal practice. And so I was wondering why you were here. I did not have that on my list, but if the parties are prepared to, if I overlooked it and the parties are prepared to address it, then I'm certainly prepared to address it. I just didn't have it on my list because perhaps I overlooked it. Mr. Jerome, when did you file that motion, sir?
I did not file that motion, but it was filed actually before I entered into the case. It was filed on October 21st, 2021.
Okay. And I mean, it is a pretrial conference. And so we do need to resolve basically all the outstanding issues so we can figure out where we're going. Mr. Barton and Mr. Obaseki, what are your thoughts on that issue, sir?
Can I be completely honest, Your Honor? I'm utterly unprepared for that motion. It was obviously filed long before my client was in the case. I assume it has nothing to do with the third-party claim by my client, and I did not understand it to be so. I haven't even looked at it, if I'm being completely honest.
And I appreciate that very much. Mr. Obaseki?
Yeah, my understanding that claim was solely and specifically against the Georgia Property Tax Solutions defendants. So
yeah, it's against the third party plaintiffs, which is Georgia Property Tax Solutions.
Okay, Your Honor, we were the ones that filed a response to Mr. Wyatt Rice's motions, and we are prepared to argue.
Okay, excellent. So we're going to take that up in just a second. Let me finish what I had on my list of things, because we do also have the motion. Well, actually, it may be dispositive of that issue, since the motion to bifurcate goes to any claims that relate to Sawaya Bryce. Okay. Ms. Claire, if you're prepared to proceed on that, and Mr. Jerome, if you're prepared to proceed on that, then Mr. Jerome, it is your motion. So please go ahead, sir.
Thank you, Your Honor. If it pleases the court. Essentially, this is a 12B6 motion to dismiss for basically there's no claim here that can be recovered. The third party plaintiff in this case is essentially trying to bring in Sawaya Bryce off of essentially 3 counts of wrongdoing, which are forgery, contribution and indemnity, and fraud. They also had 2 other counts, which were the punitive damage and the attorney fees, but those are essentially prayers for relief. To address the first count here, it's the 4 was complaint that
hang on,
filed.
sorry, hang on, Mr. Jerome, your wireless was unstable for just a minute. So if you can back up, I got everything until you said there's essentially 3 and you started outlining them.
Okay. All right. So yeah, I was saying that there are essentially 3 counts of wrongdoing. There's 3 claims of wrongdoing. The first one was forgery. The second one was contribution and indemnity. And then the third one was fraud. And so essentially what we would like to address those 3 claims and say that there isn't any recoverable action. There really isn't any claim here. And so that's why we're saying that this is essentially a 12B6 motion. Now, in regards to the forgery, there was no allegation in the complaint in terms of any forgery that was undertaken by Sawaya Bryce. Even in the defendant's own complaint, they don't make any allegations that she forged any documents. They don't make any allegations that she was a part of any forgery of any documents. So essentially that we don't understand what their claim is for forgery, because they haven't given any facts and they haven't laid out any information detailing any forgery whatsoever. So nobody's alleged that there was any forgery in this. And so we believe that that is not a valid claim. The second one is for contribution and indemnity. In terms of the contribution and indemnity, in terms of contribution and indemnity, the third party plaintiff in this case, which is essentially Alan Pendergrass. So we have all these different entities, but we know that Alan Pendergrass is really the man behind everybody here. He's the one behind Georgia Property Tax Solution. He's the one who's directing Ashley Hayes. And so essentially this is his allegation. But there has been no allegation whatsoever that Sawaya Bryce contributed to anything or is obligated to indemnify Alan from anything. Even in their own complaint, they make a claim for contribution and indemnity, but they don't state whatsoever what is Sawaya Bryce supposed to be indemnifying or contributing to in their own claim. It just states, and if we look at OCGA 51-1233, which states that the standard for contribution it says that the apportioned damages shall not be subject to any right of contribution. So the defendant is not alleging that any tort was committed by anybody. So while the plaintiff contends that the tort was committed by the defendants only and not by Sawaya Bryce, the third party defendant in this case. And the third and final complaint in this is the fraud. And so the fraud is in reference to the mortgage that was taken out. The mortgage was taken out by Alan and Ashley Hayes and Georgia Property Tax Solution. It was guaranteed by Georgia Property Tax Solutions and Alan Hayes and Ashley Hayes, and they invested significant time and money into this and into the property as a result of misrepresentations regarding the ownership interest of Sawaya. Essentially is all lands on Alan Pendergrass, Ashley Hayes, and Georgia Property Tax Solution. Sawaya Bryce was not involved in the mortgage in any way whatsoever. She did not sign any documents. There has been no testimony that she had any knowledge of the mortgage, though that they are testifying that she may have benefited some way from the mortgage. And even if that is questionable, there is no testimony whatsoever that she had any knowledge that there was any mortgage on this property, that she participated in any way in gaining the mortgage on this property, and that she was involved in that in any way whatsoever, involved in that fraud, essentially, that they committed in any way whatsoever. So that being said, the defendant hasn't stated, or the third-party plaintiffs haven't stated a claim which a relief can be granted. Even presuming the allegations contained in the third-party complaint are true, there's no basis whatsoever to join Sawaya Bryce as the third-party defendant into the case. The third-party plaintiff essentially has failed to plead the elements of the forgery, and has firmly denied that he committed a tort against the plaintiff, making contribution and indemnity a nullity. The official code of Georgia does not permit relief by the third-party complainant on the basis of contribution in the instant case, even if he is found to have committed some tort against the plaintiff and has not established that he reasonably relied upon the representations of Sawaya Bryce, who is the third-party defendant, and the representation that he alleges that he relied upon would have to be in writing and could not have been obtained by, a very cursory search of the property records of Fulton County, which would have shown clearly that Sawaya Bryce was not the owner of the property, but that Crayla Bryce was the owner of the property. So In this case, we believe that Sawaya Bryce, the third-party defendant, is entitled to a summary judgment and dismissal for failure to state a claim which relief can be granted, and to have the third-party complaint stricken completely. Thank you.
Okay, thank you, Mr. Jerome. Ms. Claire?
Thank you, Your Honor. The third-party defendant's attorney is incorrect as far as our counterclaim. And if the court were to review our third-party counterclaim against Sawaya Bryce,
Well, which I was just doing while Mr. Jerome was talking, so.
it definitely alleges facts that Sawaya Bryce was completely involved in this from the beginning, that she entered into a romantic relationship with Mr. Pendergrass, and through that relationship worked with Georgia Property Tax Solutions, including working on this deal in which she agreed to sell her own property, 1045 Lawton Avenue, that was in her daughter's name, and actually signed the deed transferring it to Georgia Property Tax Solutions. All of those facts are in our complaint. If we're going to respond to the Sawaya Bryce's motion to dismiss and motion to strike, we have to look at the fact that there's still a lot of questions here and claims that need to be answered. Our first argument was the contract between Alan Pendergrass and Georgia Property Tax Solutions and Sawaya Bryce needs to be interpreted by the court through course of performance. So Georgia statute provides that in course of performance, a sequence of conduct between the parties to a particular transaction can show that there was a contract if there's no written agreement. If one, the agreement of the parties with respect to the transaction involves repeated occasions for performance of a party, and two, the other party with knowledge of the nature of the performance and opportunity for objection to it accepts the performance or acquiescence without objection. So in this matter, not only did the agreement with respect to the transaction involve repeated occasions of performance, Ms. Sawaya Bryce also had knowledge of the nature of the performance and accepted the performance without objection. She never objected to the renovations being done on the house, nor she didn't object to Georgia Property Tax Solutions paying for those renovations. This can be interpreted as the course of performance and repeated transactions of party Sawaya Bryce. This shows she had knowledge of the contract. She never objected to the contractors that were coming to the house. She never refused to let them in to make the repairs. She participated in every single action that was done to this house as far as the contract is concerned. The contract was that the property would be renovated and that she would cooperate with Georgia Property Tax Solutions in selling the property, and then they would split the proceeds. And her actions show that she knew of this agreement and that she was actually performing this agreement. Our second argument here was the argument of promissory estoppel. And as the court knows, the theory of promissory or equitable estoppel may be used to prevent a party from denying at the time of litigation that a representation was made by that party and accepted and reasonably acted upon by another party to that party's detriment. So in order for equitable estoppel to arise, there has to be some intended deception in the conduct or declarations of the party to the stop, or such gross negligence as to amount to constructive fraud by which another has been misled to his or her injury. In this case, Sawaya should be stopped from being dismissed from this action as a party as she was asked, because there was clear and intended deception of defendants Georgia Property Tax Solutions and Alan Pendergrass in the action case. My clients relied on her misrepresentation that she was able to get the property transferred because she had that authority from CRALA in order to have the renovations done. This is what she told to them, and this is the misleading that they relied upon. She also further participated in the sale of the property, in order to get the proceeds after the renovations. Georgia property tax issues relied on this promise. Therefore, Sawaya Bryce should be stopped from being removed from this case as a party, and the claims against her should go forward. Both Sawaya and plaintiff Kayla Bryce have been unjustly enriched from these actions. And the theory of unjust enrichment applies when there is no legal contract, but when someone has benefited from the actions, the benefit applies where there is no legal contract and there has been a benefit conferred in which the result has been an unjust enrichment or compensation. And that's OCGA 927. So let's go back and look at all the facts here. Sawaya Bryce lived in this property since 2012. She's the one who was upkeeping it, maintaining it, paying the taxes, the utilities since 2012. And she still continues to reside in the property. So even after the renovations have been done by my clients, they've spent all this money, they've taken out this loan on the property, she moved back into the property and she's been living there since this lawsuit was filed. Kayla Bryce has never lived in the property. She stays there when she comes to visit in Atlanta, but she's never benefited from the actual property or the renovations. If Sawaya Bryce is removed from this case as a party, she will continue to live there and benefit from the renovations and repairs done by my clients. So she will be then unjustly enriched by all of this. And so for that reason as well, we're asking that Sawaya Bryce be maintained as a party to this action and that the claims against her should go forward.
All right, Your Honor, may I just answer real quick?
Yeah, I was trying to say that, but I had muted myself, so I apologize. Yes, Mr. Jerome, it is your motion, so I will give you the last word, sir.
All right, so let's go back to the forgery. So first of all, it seems like Georgia Property Tax Solution, Alan Prendergast, they can't get their story straight. Either Sawaya had knowledge that this was going to be a forgery and that they were still in the property from Kayla Bryce, or Sawaya did not have knowledge and this was her property. She had the authority to sign over the deed. Now, what they claimed in their third-party complaint was that Sawaya claimed to have the authority to sign over the property. If that's what you're claiming, then there is no forgery. It cannot be forgery if she's signing with authority. So then, well,
unless she lied, right? I mean, if Sawaya Bryce lied and didn't actually have authority, then it's a forgery. Also, legally, there's an argument to be made that if I sign your name, it's a forgery. Now, could it be ratified? Could I have had authority to sign your name? Sure, but it's not my name.
Yeah, but then the question would be whether or not she. So, and I understand what you're saying, Your Honor, but the question would be whether or not she lied about having the authority to sign the property. And so, if their contention is that she lied about having the authority to sign the property, and that's essentially what they're saying, and that's why they're claiming, I believe it was equitable estoppel, is that they're saying that they relied on her representation that she had the authority to sign over the property, but now essentially they found out that she doesn't. Now, we already know that Alan Pendergrass is a seasoned real estate professional. All right, he understands how transactions works. He understands how property transfer works. He understands how liens and records work. Alan Pendergrass did not reasonably rely on any representation by Sawaya Bryce, because he could have easily went to the property records and determined that Sawaya Bryce was not the owner of the property.
Mr. Jerome, let me stop you there.
Yes.
I don't necessarily disagree with you, and I'm sure the evidence will demonstrate that Mr. Pendergrass is a seasoned professional and that probably a seasoned real estate professional would not have relied on
his own deposition states it, Your Honor, and I apologize to interrupt.
That's okay, but here's the issue, Mr. Jerome. First of all, the motion that you filed is not a summary judgment motion. It's a motion to strike or dismiss, which means procedurally the court shouldn't be taking into account any of these facts. That's number one. Number two, even if I convert it to a summary judgment motion, because you guys want me to talk about and look at and consider the facts, at the end of the day, here's what we have. On a motion to dismiss standard, they've alleged causes of action under a notice standard, right? That even if forgery, to your point, to the point of your motion, Mr. Jerome, isn't technically a cause of action under Georgia law, it's certainly a factual basis for a claim of fraud, which is in that third-party complaint. And so from a notice pleading perspective, applying the standards for a motion to dismiss and a motion to strike, there's no basis to either dismiss or strike the third-party complaint. That's number one. Number two, even if I convert it to a summary judgment motion, since the parties are talking about all these facts, and I do have all these facts, at the end of the day, y'all's two arguments underscore the entire problem that there are disputed factual issues that would prevent me from entering any sort of definitive legal determination rather than a factual determination by the trier of fact as to whether or not there was fraud, whether or not there was a forgery, if there was a forgery, whether or not it was authorized or ratified, and whether or not reliance on any alleged fraud was reasonable under the circumstances. All of those are disputed fact issues that a jury, I mean, when you start talking about reasonableness, then I hear the word jury. A jury's going to have to figure those things out. And so due respect, Mr. Jerome, to your frustration on your client's part for being dragged into this. At the end of the day, it is, she is clearly someone who was involved, even if the nature of that involvement and the scope of that involvement might be disputed. And she stays in the case until we figure out, until a jury figures out what role she played or didn't play. And so the third-party complainants, the third-party defendants motion to strike or dismiss the third-party complaint against Sawaya Bryce is denied. Ms. Claire, if you could please provide me a proposed order on that issue, I would appreciate it.
Thank you, Your Honor. I'll get it submitted by 5 o'clock today.
And you don't have to kill yourself to rush. I mean, tomorrow is fine, but yeah, definitely by the end of this week so that everybody is clear and has, an order of what's been ruled on. Okay. So before we move on to the pretrial conference aspects of this and the motions in limine, I do want to revisit this issue of the motion to bifurcate. So my understanding from reading the motion is that the only entity that actually demanded a jury trial and didn't subsequently withdraw it was Sawaya Bryce. And I understood Ms. Claire to be saying, but wait, we reassert our demand for a jury trial. Is that my understanding, Ms. Claire?
Yes. And like I said before, I wasn't the attorney who filed the original answer for DPTS or Allen or Ashley, but we would like a jury trial.
Okay. Mr. Barton, what is your position on whether or not that assertion changes the argument that you've made?
I don't think it does, Your Honor, for this simple reason. Really what we were seeking to do is to segregate out these title issues from basically the cross claims for the sake of primarily efficiency. The title claims, the quiet title, the equitable defenses, those are all equity matters that the court should address directly. And again, nobody had asked for a jury trial other than Ms. Bryce, who has no involvement really in the equity matters. She's not a defendant in those matters. She's just a third party or cross-claim defendant on these essentially tort claims. And frankly, she didn't participate in the pre-trial order process anyway. And your order very clearly states that a jury demand is waived if you don't participate in the process. But more fundamentally, I guess, our thinking on these title issues is that A, they're for the court, and B, depending on how they come out, they could obviate essentially the rest of the case. And I think we could try the issues that are clearly non-jury within a day and a half or two at most, as opposed to taking up, 3, 4, 5 days of jury time. And the case may well be resolved in that 1 or 2 day time frame. So that was our thinking on it, particularly given that those issues are equitable in nature anyway. All the title issues and all the defenses, our subrogation, the estoppel issues, all of those things are equitable in nature. So that was our thinking on the issues in terms of officially trying to resolve this thing in an orderly way.
All right. Well, I agree with you. The only thing I have to do is consider even if I am empowered and authorized from an equitable perspective to assess these issues and make these determinations, in the face of a jury demand, albeit a renewed one that was waived potentially, that's what I have to figure out is, am I setting us, if I decide to go down that road, am I setting us all up for a situation where we have to go back and do it all again for a jury? And so I'm going to take that matter under advisement, and I will let you all know no later than tomorrow what I'm going to do on that issue, if I'm going to try and bifurcate out some of the claims and take them up separately. Okay, so then that leads us to the consolidated pretrial order. Couple of things. One reason, and I know we have some motions in limine that we need to address as well. One of the reasons that we have a pretrial conference is for no other reason to give you guys an opportunity to ask questions about how I conduct the proceedings. If it will be in person, whether it's a bench trial or a jury trial. I wanted to find out, I think the parties indicated an expectation that the equitable claims would take 1 to 2 days, and the jury, a separate non-jury setting, would be 3 to 5 hours. If the case were in its entirety with all of its baggage and claims were tried to a jury, how long do we think it would take?
I think 3 to 4 days, Your Honor. And just if I didn't state it clearly, and maybe I didn't, the 3 to 5 hours was intended to cover let's call it the valuation issue. So right. The value of the improvements, if it were done in a non-jury setting, as we've requested, with a couple of experts and maybe some testimony about checks that were written, et cetera, I'm viewing that as an afternoon potentially.
Okay.
And that's what that referred to.
Yeah, and I tend to agree with you. I'm just trying to get a feel for, I feel like the entire case could probably be tried in a day or two if it were a bench trial. But there would be more downtime, more explanation, et cetera, involved in a jury trial. And so, okay. One second. Everything else appeared to be in order. The only other thing I will add before we move on to motions in limine or any questions that the parties have is this. Couple of things I like for y'all to think about, assuming that it is a jury trial for a moment. Number one is, if there are claims for attorney's fees, do y'all want to consider asking if entitlement is an issue, do we want to ask the jurors just to say there is or isn't entitlement, and then the court will determine the amount based on documentation and argument from the parties, or do you wish to present that to the jury? Because you can do it either way, and so I want to throw that out there. That's number one. Number two, For the documents that were identified by the various parties, I did want to ask, or not ask, tell. So I mostly practiced in federal court before I became a judge. And so what I'm used to is a nice table that has a list of every document and its designated exhibit number. And then we can have a conversation about whether that document's going to be admitted or not. And the reason that I like to do that is that, to me, especially in a loan documents case, I mean, there's just the vast majority of these documents are going to be undisputed documents that everybody can agree. And so if you can agree that they're admissible, then you're saving the jury, me, y'all, 3 minutes for every document you need to show, because instead of having to say, I'm showing you a document that's been marked whatever and blah, blah, back and forth, you are able to just show this is a document that's already been admitted as exhibit whatever and start asking the witness questions about it. It looks as if there's been some effort to break down the documents by individual, but to the extent that any of them are summary designations, for example, photos, and you're going to end up breaking those down and producing them or introducing them as exhibits 1 through 20. They need to be broken down so that both parties before trial can say, these are the ones subject to a proper foundation that we don't disagree about. And then we'll have a real long conversation about the ones the parties do disagree about, because it just speeds up things tremendously. I don't know that I saw anything about depositions, but another place where it gets real bogged down. And I'm not talking about using a deposition to impeach or cross-examine someone, but if you guys are intending to offer deposition testimony, you need to tell me before the trial starts the lines and pages that you guys are going to be using, because what happens inevitably is that we have to stop everything for an hour while y'all figure out and highlight everything that everybody agrees to read. And the jury's just sitting there cooling their heels, and they really hate that. So that would just be my suggestion on that issue. Questions regarding pretrial or trial procedures, jury selection processes, et cetera, before we move on to motions in limine?
Your Honor, I had a question about basically the calendar. We've got almost every party in this case is out of state, including my client rep. And I gather we're on a 2-hour call, which is difficult for somebody who's going to have to get on a plane. So that was question number one. We had asked that the court consider a special setting, but secondly, if that's not possible, how long is this calendar? How long do we have to tell our clients to be standing by the airport, ready to fly to Georgia on 2 hours notice?
Okay, well, let me say this to put at least some of that at ease. 2-hour notice is it's not really how we do it, but we continue to refer to it in that manner because it makes the point that I have given you notice of the trial calendar, and so now when I call you, I need you to come. So basically, here's what it boils down to. This calendar starts on February the 27th, and I'll make it real easy for you. There's only 2 cases on it. And so it's either going to be y'all or it's going to be another case that I have a pretrial conference for this afternoon. And so the other thing that you should know is that I have 2 juries a week. So, for example, if I call in the other case first and it resolves on Monday, then I have a jury on Wednesday. And so what I would do is I would call you as soon as I know that case is falling apart and said, we're going to pick a jury on Wednesday. And the benefit of that for your clients that do need to travel from out of state is if I call you on Monday and tell you that, you've basically got 3 days now before you have to get your clients there because, except to the extent they wish to be involved in jury selection. But so I try to give you as much notice as possible, and it's always going to be at least 2 days of notice. But, we reserve the right to give less if we have to. Now, having said that, all of my calendars roll on a quarterly basis. And so you're getting called in on February the 27th. But I have juries available to me. Hang on, let me pull my calendar up. So I have juries available to me twice a week, every week. So for example, if this case doesn't go on February the 27th, it is possible that I could pull it in on March the 9th, March the 13th, or March the 15th. And the reason I mention that is because I also run concurrently a criminal calendar, which I'm sure Mr. Surge is aware of. I'm sorry, Mr. Jerome is aware of. But I have an idea of what cases those are and when they're going to be called in and whether they're going to go. And so I suspect that I don't know which case I'm going to call in first. At the end of today, I will know which case I'm going to call in first. But I will say this. The other thing I'll add is this. If I elect to move this forward on the equitable claims, to bifurcate out and try this as a bench trial, it would likely be the week of March the 6th. And I would, of course, it depends on if the other case that I have resolves or goes to trial. But I fully suspect, because the other case is set for approximately a week, that these two cases will go starting February the 27th through those two following. So there's like a 3-week period that I expect these cases will be called and will go if they go, whether it's bench or jury trial. Did that answer your question, Mr. Martin?
It did. Thank you very much, Your Honor.
Okay. Ms. Claire, I think you started to ask a question.
Yes, so we have noticed the deposition of our expert, Mr. Baggett, and we plan on taking his video deposition for the purposes of introducing that at trial, because he is out of state as well, and he won't be able to travel to Atlanta to testify in person. And so we plan on taking his deposition the next 2 weeks. So I just wanted to put the court on notice.
I did see that there was a notice of deposition. I remember wondering who that was, assuming that it was probably an expert or something. My rule is, if this is in preparation for trial, then y'all go and do as you wish. We do have the availability, depending on what the parties choose, for people to appear by Zoom for testimony. So y'all can do that if it saves time and money for people. But of course, if this person's never been deposed, then obviously y'all would probably need to take his deposition anyway. I don't know, but I don't intend to get involved in those issues, because if they're discovery issues, discovery's closed and I'm no longer involved in that. And if they are for preservation of evidence for trial, then that's just y'all's pretrial preparations. But I will again throw out there that to the extent that y'all have any witnesses who might wish to appear for their testimony and the parties agree, or if you don't agree and you want to present to me a basis for why you should be allowed, we do have the availability of having witnesses appear by Zoom and testify by Zoom. And I typically will instruct the jury the same way that I would if someone testified by depo, which is they're being sworn in and they're testifying, and you should give their testimony the same assessment that you would give if they had testified live here in person at trial. So y'all can work those issues out regarding that expert. Any other questions or issues regarding trial practice or procedure?
Now, as far as the jury instructions for attorney's fees, we would be fine with them just giving an instruction for entitlement for attorney's fees, and then having the court determine the amount.
Okay, and so y'all can get together, because to me that's really a verdict form issue in terms of how and what the jury is being asked to answer. And so if y'all can get together and agree on how that might be presented on the verdict form, I would very much appreciate that. Anything else before we move on to the motions in limine?
One other question.
Yes, sir.
You mentioned that the trial will be in person with the jury selection. I'm sorry, be in person as well.
Yes, we are back to the land of jurors in real life, in person, in our courtroom. So it's very exciting. And so, yeah, the jury would be here in person for you to select from. And in terms of the masking requirement, I believe that masks are still required to enter the Fulton County Courthouse. But most judges, myself included, in the courtroom, basically it is whatever is your comfort level. If you prefer to wear a mask, I understand that, and you are entitled to wear a mask. If you prefer not to wear a mask or don't feel the need to, then that's fine too. So I mention that only because some lawyers don't like having to voir dire potential jurors with a mask on their face. So anything else? Okay. So I have a motion in limine filed by the defendants GPTS, and then I have an omnibus set of motions in limine filed by SSA. If you guys will give me about 2 minutes to grab some more coffee, I'll be right back with you and we will power through those motions in limine. Okay. I am back. Everybody else is ready to get started. So before I get started, let me ask this. I did mention that my review of the file indicated we had SSA's omnibus motions in limine, and then we had a motion in limine filed by the defendants regarding character evidence as to the defendants. Is that all of the motions in limine that are currently of record that we need to discuss today, or are there others that I have overlooked in the record?
I believe that's it, Your Honor.
They're in the record.
Thank you both, gentlemen. Okay, so I'm going to start by I'm gonna put it. We're not going to talk about the character evidence criminal history issue yet, because I think that some of the other motions in limine are more quickly dispensed with, and I want to address those first, and then spend some time talking about the other. Starting with number 3 in the plaintiff's omnibus motion, which is this hearsay evidence of police reports and media reports containing speculation and prior consistent bolstering statements should be excluded.
Yes, Your Honor. This may not be an issue because I had to write the motion before we got the plaintiff's portion of the pretrial, and I note these documents are not listed, so maybe it's not contested, but these documents are narrative in a police report and emails and other communication with media outlets by Miss Bryce that we contend simply are hearsay and improper bolstering, and it's as simple as that. It's really all I have to offer on that, Your Honor.
Thank you, Mr. Barton. Mr. Obaseki or Mr. Williams?
We had no intentions on submitting that into evidence. That was just discovery materials provided.
Okay, well, thank you both. That makes life easy. I also would like to start by saying thank you both for not filing motions in limine that say, Judge, please enforce the rules of evidence. Yeah, because literally the number of times that I get 50 pages of motions in limine that say, please tell them that they can't offer this. Like, y'all, we all know what the rules of evidence are. We all know what the rules of procedure are. So thank you for that. So number 3, based on the plaintiff's indication that they don't intend to offer that evidence. And then moving backwards, there apparently was a stalking order between Sawaya Bryce and Mr. Pendergrass. And this goes back to me to sort of that larger issue of the romantic relationship that existed previously, and whether and to what extent we're going to get into that. Mr. Barton?
Again, Your Honor, this is a document that I was just anticipating. It's not on anybody's list. Ms. Bryce didn't submit any documents or participate in the pretrial process. Ms. Sawaya Bryce didn't. So I was just anticipating, and again, I don't know that there's any dispute over it. From our perspective as a third-party innocent lender, we think we would be prejudiced by the introduction of any indication that Mr. Pendergrass engaged in criminal activity or potential criminal activity that obviously has nothing to do with the forgery issues in the case.
Okay. Mr. Obaseki?
You know, and again, that wasn't necessarily documentation that we intended to submit into evidence.
Okay.
I would state that I think there may be some relevance to the nature of the relationship based on the allegations of fraud, but that specific document wasn't one intended to be introduced. It may be referenced.
Okay. Thank you, Mr. Obaseki. Again, that makes it easier when you guys have both considered the issue and made
But
some.
Your Honor, in terms of Sawaya Bryce, we believe that to be relevant and admissible evidence that we do intend to admit.
Hang on, one at a time. So, Mr. Jerome, tell me what issue in the case you believe that a stalking TPO that was obtained by Ms. Bryce against Mr. Pendergrass in October of 2021 has to the issues in this case?
Because some of the things that Mr. Pendergrass were saying to Soraya Bryce were somewhat admissions, and they're going to be supported by the stalking order that Soraya Bryce is intending to admit to evidence. They're admissions that he, obtained the mortgage without her permission, that he, forged the signature on the deed.
Wait, hang on. Okay, I've not seen a TPO, but usually a TPO is ex parte, and it's obtained by Soraya Bryce going to a judge and saying, hey, judge, he did all these things. Those would not be admissions by Mr. Pendergrass. Those would be representations on which the judge relied in issuing the TPO by Ms. Bryce, which Ms. Bryce can testify that Mr. Pendergrass said this and he did this and he did that. My question is there specific relevance of the TPO, number one, and even assuming there is some specific relevance, is it outweighed by the potentially prejudicial nature of the document itself? And I will add, particularly given that it was obtained ex parte.
I understand that. Well, I'll just say that the communications were used in order to get the TPO, and we believe that the TPO will bolster that. In addition to that, Mr. Pendergrass is trying to characterize the relationship between him and Mrs. Soraya Bryce as being very cozy, very in love, and very, much together, where clearly that's not true. Soraya Bryce wanted him to stay away from her, and he was the one that was continually stalking her.
Okay. Okay, so based on what I have heard, the fact that a stalking TPO is typically obtained ex parte, it would seem to me that the nature of the TPO would be overly prejudicial and not reasonably material to the issues in this case. And certainly any potential relevance, I think, would be outweighed by the danger of unfair prejudice. And so I am going to grant the motion in limine as to the stalking order. Now, as I think I've made clear, but I do want to make it clear that by ruling that, I'm not saying that Ms. Bryce cannot talk about things that are in the TPO, things that she told the judge, or behaviors that she believes were problematic, assuming that they're associated with the nature of this lawsuit. But the fact that there was a stalking order, I think, is potentially overly prejudicial. And so I'm going to keep that out. Is everybody clear on that? Okay.
I'm sorry. I have a question. You said
yes, Mr. Obaseki.
The fact that there was an order you're keeping out, but you're allowing her to testify to the fact that she went to a judge?
No. My understanding of what Mr. Jerome was saying is that she told the judge, these are all the communications that I found harassing, and that they have to do with this transaction. And so my point is, by saying that you can't bring up the TPO or talk about the TPO doesn't mean you can't talk about the stuff that's in it, right? Like, I'm not saying that Ms. Bryce can't say, he emailed me and said, you signed this document, you lied to me, whatever, because those happen to be things that she told the judge. That's what I'm trying to clarify. But also, to make it a little bit easier, I will tell you it is my standard practice, because that's what the Court of Appeals requests and prefers. I will enter a written order on the motion in limine. And so you will have it in front of you. And what it will, I can tell you, say is the fact that a stalking order was obtained and the stalking order itself, I think, are overly prejudicial. But that information contained in that stalking order, that's still fair game if it's otherwise relevant to the issues in the case. Now, having said that, we're not, there's always the possibility that somebody opens the door, but I will also remind you that if I have entered a written motion in limine and you think somebody has opened the door, you don't get to decide that yourself. You have to say, hey, judge, I think that they opened the door by saying this. And so now I want to get into the stalking order, and then I will give you a ruling. But you will still be in violation of my motion in limine if you just on your own start talking about the fact that there was a TPO or referencing that document. Okay. And then that takes us back to sort of the primary issue, which is the subject. And I think they're basically the same. It might be the one thing that SSA and the defendants agree on, is that both SSA and the defendants, GPTS, Ms. Hayes, and Mr. Pendergrass have moved in limine to exclude any evidence of criminal history or other alleged bad acts by Mr. Pendergrass as being improper character evidence. Mr. Barton, I'll hear from you, and then Ms. Claire, if you have anything to add, y'all can sort of go together.
Sure, Your Honor. Very, very briefly, and I think the perspective from which SSA brings this motion might be slightly different than the GPTS defendants, in the sense that nobody contends that SSA was involved at all in any of the underlying wrongdoing here and was an innocent party who lent money. And our concern is that if bad acts of any of the defendants is brought into the case, that we'll end up getting painted with those bad acts here. And I guess the way I look at this case is that the forgery issue is really pretty simple. I mean, we've already discussed the fact that Miss Bryce's name didn't appear on that document by her hand. The question is, did Sawaya Bryce write it and notarize it? And did later Miss Bryce, the plaintiff, ratify that signature, or was it authorized? And so it just seems to me any potential relevance of Mr. Pendergrass's criminal history, and I'm using, or bad acts, and I'm using that phrase broadly because I don't exactly know what it is we're talking about. You know, there's been lots of testimony in the case that Mr. Pendergrass has done this kind of thing before, or he has swindled other people, or he has stolen from other people. There's lots of sort of loose testimony about that.
And Mr. Barton, I'll agree with you there that the only information I'm aware of that's even slightly more specific is that there are some documents that the plaintiff has, like in pleadings or motions, that have identified a specific case number for, I think, 2 federal prosecutions associated with Mr. Pendergrass, but I'm not aware of any certified copies of any convictions. I'm not aware, but maybe there's evidence in the record that there's an admission to that. I don't know, but whether it's relevant and admissible begs the question of whether there is sufficient evidence of those things to come into evidence in the first place. Go ahead, Mr. Barton.
Agreed. So that's why our motion is a little wide open. But at the end of the day, as to any of it, from our perspective, whatever potential relevance or value, probative value it might have here would be wildly outweighed by the prejudice that would be visited upon SSA. And this bleeds over into, for example, why we filed the motion for bifurcation and or why we asked to have our valuation evidence severed in the event the rest of it goes forward with a jury, is because we simply don't want to be tarred by whatever the bad acts are, whether it's a properly authenticated criminal history or not. We'd obviously be way less concerned about this if all of our part of the case were being tried to the court. But we're very concerned about this information being put in the record in front of a jury.
Okay, thank you, Mr. Barton. Ms. Claire?
Thank you, Your Honor. So the plaintiff did, as you mentioned in their amended complaint, 2 cases, previous cases, criminal of Mr. Alan Pendergrass, one in the U.S. District Court of Ohio Eastern Division, and that was in 2014. and then another in the Northern District of Georgia in 2017. Neither one of these cases have any relevance to this current matter. And the defendant's position, Alan Pendergrass, is that they shouldn't be introduced in any way because they would present a bias and prejudice to him. The Georgia courts have allowed for previous convictions and charges to be excluded as inadmissible character evidence or previous bad acts evidence in several instances. We cited to State versus Dowdle in our motion, in which the appellate court found that jurors may be tempted to convict based off of their belief of what the evidence says about the defendant's character, instead of rather just the evidence in the case itself that's being tried. And so we don't want the jurors to get an impression of Mr. Alan Pendergrass before they can really consider the facts of this case and what's relevant to this case. The rules of evidence are also very clear that any prior bad acts are inadmissible character evidence for procedures in civil matters like this one. The 11th Circuit applies a three-part test to determine the admissibility of evidence of other crimes and acts. And this is under Rule 404B. The evidence.
And just so you know, Ms. Claire, I am very familiar with 404B and the recent case law on it because I deal with it all the time on the criminal side of my docket. So I'll save you a little bit of trouble in that regard because I know exactly what three elements you're about to cite to me and the process that the court has to engage in to determine if such information would be admissible because it's relevant. And then even once you decide whether it's relevant and would be potentially admissible, is that relevance outweighed by the potential for unfair prejudice? So please go ahead, Mr. Claire.
Okay, so I'll skip the elements, but the main point is the relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, fusion of the issues, or misleading the jury, or by considerations of undue delay or just a waste of time in the needless presentation of this type of evidence. And so we are asking for the court to exclude any previous bad acts or criminal acts of Mr. Pendergrass as irrelevant here. And also because any relevance may be outweighed by the prejudicialness of the information presented to the jury.
Okay, thank you, Ms. Claire. Mr. Obasaki?
Thank you, Your Honor. And just to be clear, and perhaps maybe somehow in transference of everything, the actual documents were never submitted to opposing counsel. I know that the citations for the case numbers have been submitted multiple occasions, both myself and prior counsel. But we do have two cases, as Ms. Claire noted. One is the most recent case, which I believe was a conviction as recent as November or December of last year. Mr. Pendergrass was charged with 10 counts, 5 counts of mail fraud.
Well, let me back up for a second, Mr. Obasaki. So I'm willing to grant you that you either have or could get prior to trial appropriate evidentiary support for these other incidents. The real question, to Ms. Claire's point about the 404B analysis, is for what purpose would you be offering them? And is that purpose an admissible purpose? An acceptable purpose?
And that's why I wanted to list the specific charges. Because I know I've listed the cases, but I think the charges are important to verify and show why this evidence would be admissible and not unduly prejudicial. Because primarily what we have here, factually, the undisputed things, is Crayla Bryce has a property that was somehow transferred to Georgia Property Tax Solutions. The question, of course, Ms. Claire's clients were saying Sawaya signed it. Sawaya saying she didn't sign it, and somebody else from Georgia Property Taxes, likely Alan Pendergrass, signed it. and whether or not there was a fraud there and whether or not that fraud was ratified. One of the things that has been brought up even during the course of this pretrial conference is whether or not Mr. Pendergrass knew or should have known that Ms. Sawaya Bryce had the authority despite his years of experience as a real estate professional. So some of these criminal convictions go to, I think, the point of motive, opportunity, absence or mistake of facts or accidents, all those things that under the statutory law are very clearly separate and apart from simply character evidence.
Right. And Mr. Obaseki, and I appreciate that because that's where I was trying to get you, right? Is what is the proper purpose, not the improper character reason, but what is the proper purpose? And so now what I've heard you say is his motive, his lack of mistake, his knowledge plan, et cetera, correct?
Yes, this is a common scheme type of thing that's been going back to 2014 in multiple jurisdictions. And there's a guilty plea in the Ohio case and a conviction in the Northern District of Georgia case, all within 10 years. It also goes to impeachment purposes, which of course, Georgia law is very clear that evidence of commission of a crime involving moral turpitude is admissible for purposes of impeachment. Here, all these counts are fraud related, identity theft, money laundering, etc., which again goes to this whole knowledge thing and the scheme. And I think that's all very clearly admissible under a number of different ways that it could come in.
Well, Mr. Obaseki, forgive me for interrupting you, but let me ask you a question. So let's say I agree with you that you stated a proper purpose and that there is some basis for relevance. Do you agree with Mr. Barton? Basically what Mr. Barton's argument is that the prejudice analysis is different as to Mr. Pendergrass versus the SSA, the innocent lender, as Mr. Barton would characterize his client.
I don't agree under these circumstances because again, there's not been any allegation by us regarding the lenders. Only thing we're asking from the lender was quiet title. In terms of the forgery, punitive damages, attorney's fees, those are all against the Georgia Property Tax Solution defendants. I recognize and understand that, and we can clarify that through, I think, jury instructions to the jury in terms of what evidence will be used against what party. But primarily here, what we have is evidence that's clearly relevant for the purposes of showing the knowledge, motive, intent, etc. for Mr. Pendergrass. And I don't believe it would be prejudicial to SSA assets because our claims aren't against SSA assets for any of those things. They're only against SSA assets for the quiet title.
Okay, thank you, Mr. Obaseki. Mr. Jerome, do you have any position on this?
Yes, and I just want to just specify, and I'm just building on what Mr. Obaseki already said, but specifically we would be bringing in these prior criminal acts to show motive, to show opportunity, to show knowledge, and to show the absence of mistake or accident. And obviously, every time you bring in evidence about a person's character, anytime you bring in prior criminal history evidence, it's going to impugn a person's character. But it's independently admissible under impeachment rules. And so I believe that there's sufficient basis here to bring in those prior criminal acts.
Thank you, Mr. Jerome. Okay, so for procedural purposes, let me say this. The defendant's motion in limine regarding improper character evidence or evidence of Mr. Pendergrass's prior criminal history is denied based on assuming that plaintiff will present the foundation, right, that the appropriate foundation at the appropriate time. It appears to me that the plaintiff has identified a proper purpose under 404B, that this information and evidence would be relevant to demonstration of that proper purpose, that it is material to the issues in the case, and that its prejudicial value or prejudicial, that the concern of prejudice is outweighed by its relevance as to the claims between the plaintiff and the defendant, Mr. Pendergrass. So I am denying the defendant's motion in limine on that issue. I am reserving ruling on the SSA's motion in limine, and here's why. I think that it begs, as Mr. Barton pointed out, it begs the question of this issue of bifurcation on the equitable issues. And even Mr. Obaseki said, look, our only claims against the SSA are associated with acquiring title and the extent to which there is or is not a lien based on the funds that were borrowed. And so it may be that the way to avoid that prejudice and still allow the plaintiff to present the case that it's entitled to present against the defendants is to bifurcate those equitable issues so that we would avoid the potential unfair prejudice to SSA because of the introduction of evidence as to Mr. Pendergrass's prior criminal history. I'm not ruling on that issue right now, but I'm just sort of giving you an idea of what my thought process is there while I continue to take under advisement the motion to bifurcate and the SSA's motion in limine on that issue. Of course, if I decide to bifurcate, then that motion is, I think, obviated. And if I decide not to bifurcate, then I will give you guys a ruling on how we're going to navigate that particular minefield. Anything, I think those are all the motions in limine. Are there any other matters that the parties want the court to address while we are all together?
Nothing from SSA, Your Honor.
No, Your Honor, I think we covered everything.
Okay.
Yeah, I think the only thing outstanding is the deposition for Ms. Claire's expert, which I guess hopefully we can get scheduled soon. But obviously that may push, depending on when that does take place, that may push back the February 27th trial.
No, sorry, it won't. If y'all are unable to accomplish that deposition, then we will figure out what to do about it from an evidentiary perspective. But the trial starts when the trial starts. And the fact that y'all have chosen to engage either in out-of-time discovery or to preserve testimony for trial is entirely up to y'all, but it will not delay the trial. Yes, ma'am, Ms. Claire.
I do have one more thing. I wanted to bring to the court's attention that third-party defendant Sawaya Bryce and her attorney, Mr. Jerome, didn't participate in our pretrial order at all. And so that anything that they may try to produce as evidence will be objected to, since they didn't provide us with any list of items that they would be producing in evidence, or even how long their case is going to take, or any information of that nature. So I just wanted to address that.
Well, we participate in a discovery, and so we provided all the information that we intend to admit.
Your Honor, I respectfully disagree. We submitted discovery to Ms. Bryce, and it wasn't responded to. Now, we didn't file a motion to compel because I didn't think it was worth it. But the idea that Ms. Bryce participated in discovery as to SSA, I will say is simply not correct. And I do echo what Ms. Claire has said, is I am concerned about some last minute, surprise document or witness or attack by Sawaya Bryce having not participated in the pretrial process at all and having not answered any of our discovery questions. I didn't think it was worth filing a motion to compel, but I am concerned about the failure to participate in the process.
Okay. So the easy answer to that is that one of those thank you for not filing a motion in limine that asked me to please enforce the rules, is that if you did not, that at trial, we will not be discussing documents that were not produced and exchanged and discovered during the process of discovery. And so to the extent that Ms. Bryce did not respond to discovery, then I would assume that the universe of documents that Ms. Bryce, Sawaya Bryce, would be allowed to rely on would be those documents that are part of the record because they were produced by SSA and or by GPTS and or by Crayla Bryce. And that will be the limitation. And it is my intention I hew pretty close to that. If they're now, the only caveat to that I will say is this: if you're going to tell me it was never presented in discovery, then I need you to point to where it was asked for. So other than that, if it was asked for and it was not provided because, you know, no responses were given, then yeah, I'm not going to hear additional documents and evidence that are going to be presented at the 11th hour at trial. Anything else? Yes, sir, Mr. Jerome.
Yeah, Your Honor, we did participate in discovery. Specifically, JFW. Well, you know what, we could we'll address it if the issue does arise, but I do see that we did participate in discovery with JFW and with Georgia Property Tax Solutions, and
okay, well,
so,
it sounds as if that is a matter that we will, we may or may not have to deal with. Of course, it's my hope that the universe of documents that have been identified by SSA and by GPTS and by Crayla Bryce are the universe of documents to which we need to focus our attention, and that it wouldn't be necessary to get into the weeds of other documents. But if it does arise, I will just remind everybody that you need to ask me first, because the quickest way to blow up this trial and make us have to start over again is by, without authority, violating a motion in limine or another order of the court, or offering into evidence a document that's not previously been produced, or about which the other not identified in the pretrial order. So I'm not saying those things won't happen, but if they are outside that universe, it's something that you need to say, hey, Judge Krause, this is what I have, and I think I should be able to offer it because, and then I'll hear from the other side as to why they object. And we will go from there. Anything else?
Your Honor.
Okay. Yes, sir. Last thing I did want to add is just that my courtroom is if you, to the extent that you wish to be a way with, you know, a big blow up on an easel, right, which I'm a big fan of, but to the extent that you're planning to share paper documents, there are two things you need to know. One is I have everything's done by Zoom. So if you're going to use electronics to demonstrate, like if you're going to use a computer, PDFs, that sort of thing, what will happen is you will log into a Zoom, and then you will share your screen, and it'll go onto a big board and on all the boards in the courtroom, and the jury will be able to see it and I'll be able to see it. So that's how you would share that evidence. And if you want to come and figure that out before the trial starts on the 27th, then all you have to do is reach out to Mr. Freehoff, and he'll put you with court technology and you can make those arrangements. That's number one. Number two, though, is that if the document is not already agreed to, right? So you need to put that document in front of that witness and have that witness identify that document and lay a proper foundation for it before it can come into evidence. It needs to be a piece of paper. And that's because it's doable, but it's really clunky to try to pull up a document just on the screen in front of the witness and in front of me and not on the big board for everybody to see. And most lawyers will tell you, I get real angry if you throw a document up on the board that's not been properly admitted into evidence. Okay. So I often recommend, if the parties want to agree, just put a notebook together of all the documents that everybody agrees and put it on the witness stand. And that way you can just refer the witness to, hey, look at tab number 7. And then once they identify it, you can throw it up on the board. So Thank you all very much for your time. I will look forward to the proposed orders that I've requested from the parties on the outstanding motions. The only other one is if the parties would please provide me with a, I take it back. I'm going to do the motion in limine order myself because it's pretty straightforward. And I will have those for you later today or tomorrow. And then by tomorrow, I will be able to tell you which case is being pulled in on Monday, the 27th. And then we'll go from there. Okay. Thank you all. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor.